All right, the jury. President
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, everyone. Thanks you for being back on time, ready to go. At this time, I want to give you some preliminary instructions about how we're going to proceed logistically and a little bit of the law that applies to this case. First of all, you can sit anywhere in the jury box when we're coming and going. There are no assigned seats. If at any point you need anything, you can get in touch with Deputy Scott, or he might have shown you the light switch back there so that we know if you need something. That can be helpful. When you're all back and accounted for from lunch, you can flick that switch so we know you're ready to go. And again, make sure to wear those juror stickers when you're out and about. Anyone associated with this case, including me, with the exception of Deputy Scott, is prohibited from having any contact with you whatsoever outside of this courtroom. I see several of y'all have found the pens and notepads that we've provided for you. Few notes about those notes. You can take notes, but you're not required to. Please do not let your note-taking distract you from paying full attention to the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case. Notes are not evidence, they are only memory aids. They are not more important than your own impression or memory of what the evidence may have been. While you may consider another juror's notes to refresh your memory, you should rely on your own memory of the proceedings. You must leave your notes in the jury room except when you're in the courtroom. They will be destroyed at the end of your deliberations. This is very important. You will not get a transcript of any witness's testimony. Oftentimes people ask in the middle of deliberations, can you give us that transcript? We need to find that one little point that's so important. And the answer is no. Sometimes it can take months or even years to prepare a transcript, and so that's not something we do in real time. So you have to remember what these witnesses say in the way that works best for you. Before we start, I want to cover some basic principles of civil law and explain everyone's role and how we're going to proceed. As I mentioned to you before, the case you're considering is Hyman Park as plaintiff versus Chung Sup Lee as defendant. And under our legal system, it's my duty as the trial judge to determine the law applicable to this case, and it's your duty as the jury to determine the facts of the case. It's also your duty to apply the law that I give you to the facts that you find in reaching your verdict. You determine the facts from the evidence, which consists of two things: testimony and exhibits. Testimony is the statements that you'll hear made under oath from the witnesses. Exhibits are documents, photos, or other items that will be admitted into evidence. You'll then have those exhibits with you in the jury room for use during your deliberations. Caution you that what the lawyers say during this trial is not evidence. Nothing they say in their openings or arguments or at any other time when they're asking questions is evidence, nor is anything I might do or say evidence. I have no leanings in this case whatsoever, and my interest is simply to see that it is tried fairly for both parties and according to the laws of the state of Georgia and according to the Constitution of this state and the United States. You must consider this case as a lawsuit between persons of equal worth and equal standing in the community, and between persons holding the same or similar positions in life. All persons stand equal before the law, and all persons are to be dealt with as equals in a court of justice. In a civil case, the party bringing a claim has the burden of proving their case. And so for the plaintiff's claims or for the defendant's counterclaims, each party must prove their case by what is known as a preponderance of the evidence. Proof by a preponderance of the evidence simply requires that the evidence show that something is more likely true than not true. The object of all legal investigation is the discovery of truth, and rules of evidence are designed with that purpose in mind. So during the course of their trial, there may be objections made by the lawyers, and I have to make rulings in response to those objections. Those objections and the rulings are going to concern the technical rules of evidence. You don't have to worry about those. Don't draw any inferences or assumptions about the objections or about my rulings. When evidence is not admitted because of an objection, that's something you cannot consider. If there's ever a complicated objection, we may need to take that up outside your presence, so we'll excuse you to the back. We'll try to limit those interruptions, but again, we ask you to be patient. When you're in the back, chances are we're out here working. You may also consider the number of witnesses, but the preponderance of the evidence does not necessarily lie with the party who has the greatest number of witnesses. A civil trial generally proceeds as follows. The attorney for each side has the opportunity to address you in what's called an opening statement. The opening statement itself is not evidence, and what the lawyers say is not evidence. It's just a preview or outline of what each party expects the evidence to be. The plaintiff will go first in this case. After the opening statements, the plaintiff will begin by presenting evidence. That means they can call witnesses and introduce any exhibits. And then the defendant has the right to cross-examine those witnesses. When the plaintiff has presented all of their evidence, the plaintiff rests, and the defendant then gets that same opportunity, and the plaintiff has the opportunity to cross-examine. After all the evidence has been presented, the attorneys have the opportunity to make a closing argument. And there, the attorneys will attempt to point out certain parts of the evidence that they think are persuasive or favorable to their position. Both sides have the opportunity to make this closing argument. After the closing arguments, I'm going to charge you on the law that applies to this case, and then we'll ask you to retire to the jury room to deliberate and reach your verdict. Please remember during the course of this trial to listen carefully to all the evidence. Do not jump to conclusions before all of the evidence is presented. And please remember that during the course of this trial, it would be improper for you to discuss the case with anyone or allow anyone to discuss the case with you or in your presence. You can't discuss the case even with each other in the jury room before actual deliberations begin. And even at that point, only when all of you are present. To maintain that integrity of the jury system, you have to decide this case based only on the evidence admitted during the trial and the law that I explained to you. You may not conduct any research on your own about this case or about any of the people or places mentioned. You can't visit any of the places. You can't refer to any books or documents that weren't admitted. And you can't use dictionaries or other reference materials. Don't use Google or otherwise search the internet or any blogs or use anything electronically to get information about this case or anything involved in this case. Simply put, everything you learn happens right here. You are the ones who have been qualified as a fair and impartial jurors, and that's why you shouldn't let any of these influences or even anyone at home tonight in your household affect your decision through discussing the case with or around you. All right. So at this point, I believe that covers my preliminary instructions. So as I mentioned, we would now turn to the parties to make their opening statements. So Mr. Collins, when you're ready to proceed, the floor is yours.
Good afternoon, ladies and gentlemen of the jury. As you know, my name is Matt Collins, and I represent the plaintiff in this case. I'm not using the microphone right now because generally everyone can hear me as is. However, if anyone cannot hear my voice, please let me know. I'm happy to start using the microphone. In the interim, I'm going to go ahead and just talk to you and tell you a little bit about this case. As the judge mentioned, opening arguments are not evidence. So what I'm going to show you is what we expect the evidence to show. And so at the end of this case, when I make the closing argument on behalf of Mr. Park, I'm going to come back and say, you remember what I said in the beginning during my opening? I said, I expect the evidence to show. And then at the end, we're going to come back and there's going to be an accounting, a reckoning. And at that point, I'm going to come to you and say, you know what? I said I'm going to do this, this, and this. And we're going to show you that we did, in fact, accomplish those goals. So let's start with what this case is about. This is a partnership dispute. The central dispute involves profits from a skill gaming center. So what is a skill gaming center? Well, the evidence is going to show that a skill gaming center can be a retail location, can be a dedicated amusement center. It can also be a convenience store or a gas station. In this dispute, we're dealing with a retail location, which is something that's very common in North Carolina. In Georgia, you see a lot of these skill games in convenience stores and in gas stations. So that's why we made the discussion with you about convenience stores, is because that's where most of us have seen these skill gaming machines in action. But in this particular case, the evidence is going to show it was a dedicated amusement center, a room that was rented, that was outfitted with two kinds of machines. You know, games of skill involving computer machines and games of skill involving what looks like slot machines. Now, games of skill feature legal games of skill. It is not a slot machine. They require player skill, not pure chance. So a slot machine is the button you put your coin in, you press the play button and the wheels spin and it stops and it's all pure chance. You have no real control over what happens, whether or not you win or lose. The distinction is that a game of skill, a skill computer game, requires some work and some effort by the player, and they can improve their skills and do better with practice. So therefore, there is a legal distinction. So skill computer games and skill games are legal, both in Georgia and in North Carolina. In both situations, the game rooms are licensed, they get permits, and they pay taxes. And so it is a totally legal proposition. And Mr. Park has been involved in the skill game business for a long time, and you're going to learn all about his experience in operating a skill gaming center. So the key distinction is the difference between a game of skill that requires practice, technique, experience versus a gambling machine, which is just pure chance. And that's really the distinction that we're going to show you in this case. So while some of these skill games may look like a slot machine, may operate as a slot machine, the player has controls that allows him to exercise his skill and experience and have a chance to win. So most of the games that we're going to be talking about in this particular case are going to look like computers. They're not necessarily going to look like a slot machine. Not going to look like a big machine like you would see in Las Vegas, where a screaming wheel of fortune at you as you walk towards it. Those are gargantuan machines. These are smaller. A lot of these machines are going to look like a computer and a screen, or they're going to be what they call a stand-up machine, where you walk up to the machine and you play a game on that. Unlike slot machines, these require strategic input and creating a way of identifying winning patterns. And that's the skill element that I want you to think about. So the outcome is determined by the player's skill, the player's ability to recognize patterns, and the player's ability to use their mental effort to gain a victory. All that is to say, that's the product or service that is being contracted for in this deal. Running a retail establishment with skilled games. Other than that, it could be any kind of item, good, service, or product that's being sold, because at the end of the day, this is a contract case. And I want to go ahead and talk to you about Sean Lee and Mike Park. They were partners in a business called SM Men Enterprises LLC. But the trade name for that company, SM Men Enterprises LLC, was 210 Sweepstakes. And so the 210 Sweepstakes, why? Because it's on Highway 210 in North Carolina Highway 210. So that's where the name come from. The evidence is not going to show that there was any reference in the name to the products and services. It's really a location description. So this company operated the North Carolina Skill Gaming Center. And so that's going to be the location where the business was located. We're here in Georgia because both the plaintiff and defendant reside here in the metro Atlanta area. And in fact, throughout this period of time, they both resided in the metro Atlanta area. So let's talk about what each partner brought to the table. You see that on the screen here. Mike Park is the operator. He has extensive experience in the skill gaming business. He is, at the time they did this deal together, Mike Park managed two separate skill gaming centers. So he was already an experienced operator looking to add a third. The evidence is going to show that Mike Park brought to the table the ability to select the best location, to find a location that was going to draw in the players, to draw in people who wanted to play the games, who would enjoy playing the games. The next issue is the selection of what games to put in there. Well, Mike Park's going to testify, we expect him to testify, that when it comes to selecting games, you have a lot of choices you can make. That you can get games that target people based on age, demographics, skills, what kind of lively atmosphere you want to have, whether you want it quiet, whether you want it lively music and boisterous. The evidence is going to show that Mike Park has found the most success at targeting specific demographics. And he's going to explain to you how he selects games that are going to be attractive to the demographics that he likes to choose. The evidence is going to show that Mike Park brought to the table the ability to develop financial reporting systems, to establish marketing strategies to go after that target market. So he's going to select the games that are going to be most attractive to the target market. Then he's going to market those games to the people that we want to bring into the store. He's going to also, throughout this whole process, always be looking for additional locations. Where can he go next? Because after all, once you get the business up and going, once Mike Park has started training and has employees who are trained, he'll still need to be a presence in the store and make sure the store is running correctly. Then he can start moving on to the next project. And in fact, I expect the evidence to show that Mike Park was already looking at other locations. It was getting ready to start those locations as well. As a successful entrepreneur, Mike had the ability and the experience and the skill to bring a business from concept to opening, and then move on to the next project. Now, the evidence is going to show that Sean Lee had no experience in gaming, that was not something that he had been involved in, that he wanted to learn from Mike Park. So he agreed he would be the silent partner. After all, since Mr. Lee did not have experience in gaming, it wouldn't make sense for him to be the operator. Now, the evidence is going to show that Mike Park was willing to work with Mr. Lee if he put up the capital to start the business. And Mr. Lee committed to invest up to $150,000. Now, there's going to be dispute about what Mr. Lee actually invested in the business. So I'm going to ask that you listen to the evidence, and you can make the decision about what dollar investment he put in. I would submit it really doesn't matter. What matters is what happened after the business started running. Let's talk about the timeline. So I want you to know what happened to when and what we expect the evidence to show. So this whole process began in the summer of 2019. I would suggest it actually started before then, because the evidence is going to show that Mike Park identified the new location in North Carolina in the fall of 2018. Why we start this timeline in the summer of 2019 is because that's when Sean Lee entered the scene. And Mike Park was looking at this location in North Carolina, Highway 210, in the fall of 2018, but he didn't have the ability to open it. He had all these other projects going on. So it was there. It was something he was going to do at some point. But then when Sean Lee came to Mike Park and said, look, I want to be a part of your next gaming center. They came together on a deal. Mike pulled out this particular piece of property because he felt like it would be a good fit for all the things that he was looking for. So in the summer of 2019, Mike Park and Sean Lee came together and put together their deal. And then on September 1st, 2019, Mr. Lee signed the lease agreement. Now, this lease agreement, this lease agreement was designed to be a 2-year term that could be renewed and could be increased for an additional 10 years. So everyone involved in this situation was thinking of this as a 12-year business commitment at a minimum. The 2-year term plus a 10-year renewal. And so if we think about it as 2 years, that's really not correct. You gotta think about it as a 12 years business opportunity. So Mike Park brought the location, the lease got signed, and at that point, all we have to do from September to opening is get the space ready. And that's where we had this discussion about what money was spent, what would need to be spent to get the property ready to go. There's going to be a lot of discussion about what was done during that period of time. But we know for a fact that in December 16, 2019, Sean Lee needed money. He could not complete the build out of the building based on his own funds. And the evidence is going to show that to to solve that problem, he did a deal with Jamie Madden. Now, Miss Madden did not know Sean Lee at all. She was a friend of Mike Park. So this is another example of Mike Park facilitating through his contacts the ability to get a deal done. Sean Lee needed $50,000 to finish the renovation of the property. Jamie Madden was interested in putting her money to work and making a good return on her investment. So they came together with a deal for Jamie Madden to buy 10% of Sean Lee's shares. So we remember we started off as 50-50 partners. So now Sean Lee sold 10% of his ownership to Jamie Madden for $50,000. And with that $50,000, Mr. Lee completed the build out of the property. So at the end of 2019, the build out was completed and the store was able to open. Mr. Park ran the store for January, February, and then into the start of March of 2020. And guess what happened in March of 2020? The whole world shut down because of COVID. Now, Mr. Park didn't want to close his store. However, the health officials told him he had no choice. Everything, all these, especially establishments like a game room, where you're all in there together, there's no way that you could keep that open during a transmission disease like COVID. So therefore, it had to close. The good news is that the store reopened in September of 2020, approximately, sometime in the late summer of 2020. The North Carolina health authorities allowed them to reopen with the masks and social distancing and all the rules. If you recall that we all had to go through at that point in time, all those rules allowed the store to reopen. So in September 2020, the store reopened. However, there would be a real difference. The difference is that Mike Park would no longer be the operator, but that Sean Lee would be the operator. And so the store opened in the summer of 2020. Sean Lee took over the operations role. Mike Park became a consultant or sort of a silent partner role. Nothing changed about their partnership agreement. The partnership agreement stayed the same. We know that Sean Lee took over and ran the operations for that September 2020 date. We know also that at the end of the first lease term in August of 2021, basically a year later, the landlord sent a notice of termination to Mr. Lee and told him, you are not going to be able to renew that lease. The landlord said, you are not going to be able to get your 10-year extension. The landlord said, you're not doing what you promised to do. You're not doing your end of the bargain on the lease. And so therefore, we're going to terminate it. Well, you look at the termination notice, and it looks really black and white, that the lease would end on August 31st or at the end of the month. However, the evidence is going to show that even though the lease had ended, and even though the landlord had sent a notice of termination, that the business still stayed open, that Sean Lee was able to continue to operate the business. The evidence is going to show that Sean Lee operated that business until November of 2022. The evidence is going to show that there is a total of 27 months that Sean Lee operated that business. So let's talk about what happened during that 27 months. During that 27 months, Sean Lee did not provide any financial records. He did not provide any financial statements. He did not provide any revenue documents or verification. He did not show any expenses. None of the information that you would need to say, gee, how's the business doing? I mean, if he had provided this and the business wasn't making money, then you could say, all right, we're not making money, I shouldn't get a distribution. But because we got nothing during those, for records, what did we know? Well, we know that he ran the business for those 27 months. We know that Sean Lee provided no details of operations. Thank you. No details of operations. The partners were kept entirely in the dark. The partners, of course, remember, is Mike Park and Jamie Madden. So we've got two partners that have the right to be told what's going on with their money, with their business. No reports at all. no bank statements, no nothing. But most importantly, when you make an investment, you want to know, are we getting any distributions? We want to know what is going on with the profits. The evidence is going to show that running a game room is a very profitable business, that it should be successful, that there is no reason why it will not be successful. In fact, the evidence is going to show that in just 2 months of Mike Park running that business, he got it immediately profitable. It was profitable on day one, and that it was generating tremendous revenue. Now, of course, that all came to a stop in March. So there was no revenue at all between March and September when the business reopened. But there should have been that same ability to grow the revenue right away when the business reopened. So the partners, Ms. Madden and Mr. Park, did not get a dime during that 27 months. Where did the money go? There's only one conclusion. All the money had to be kept by Mr. Park, by Mr. Lee. We don't know what Mr. Lee did with the money. We don't know what he spent it on, but we know that he did not give any of the revenue to Mr. Park or to Ms. Madden. So let's talk about the agreements. So we have 3 agreements that are going to be an issue in this dispute. First, we have the verbal agreement. Yeah, there's no doubt it would have been much better if there had been a written contract. There should have been a written contract. The fact is, the evidence is going to show that Mike Park has extensive experience with handshake deals. More importantly, Mike Park has extensive successful experience in a wide variety of businesses. So Mike felt like he had the skill and ability to choose partners that would allow him to be successful, that would allow them to be successful. So when he takes a witness stand, he's going to be able to explain to you his success, the businesses he's been in, and why he thought the Sean Lee deal was going to work as well. And so while we all can say, gee whiz, wish there was a written contract, the fact of the matter is there isn't. And, there isn't, and the evidence is going to show that that's not unusual for the way that Mike Park typically has done business in the past. The evidence is going to show that they started off as 50-50 partners, that Mike Park would be the operator, that Sean Lee would be the silent partner, and that Sean Lee was really interested in this business. And the idea was that Sean Lee would learn from Mike Park, that he would be able to invest that $150,000 to build a store, not only get a return on his investment through profits, but that he would also be able to learn how to operate a business. Now, of course, Mike Park did not know that Sean Lee would use what he learned to lock Mr. Park out of the business. But the evidence is going to show that that's exactly what happened. Now, the second agreement is an investment agreement. This is the deal between Ms. Madden and Mr. Lee. You'll notice that Mike Park's name is not on here. Mike Park was not a part of this. He made the introduction. Sean Lee said, I need cash to finish the build out. Ms. Madden came to Mike Park and said, I'm looking for a way to invest my money. Mike Park brought the 2 people together. So the 10% shares was from Sean Lee, not from Mike Park. So the evidence is going to be very clear that the deal was between those 2 individuals, and that that the shares were sold from Sean Lee to Ms. Madden. In exchange, Sean Lee received the $50,000. The purpose of that money was to complete the store renovations. The deal was done and the store renovations were completed. So the third contract that's involved in this deal is the lease agreement. So this is, again, the lease agreement that Sean Lee signed, but it was on behalf of the company. So he was signing as the manager of the company, signed with the landlord. And so this was the 2-year term with a 10-year extension, and that the lease was ultimately terminated by the landlord before the end of that 2nd year. So right before year 2 expiration ended, that termination prevented the opportunity to get that 10-year extension. So therefore, we have 3 owners of this business. So We got Mike Park, who's a 50% owner. We have Sean Lee, who is a 40% owner. And we have Jamie Madden. Miss Madden is the 10% owner. So that is the ownership group that was involved in this business. Let's talk about Jamie Madden. Mike Park brought her to this deal. He convinced her to invest and he introduced her to Sean Lee. Make no mistake, she was buying 10% of the business from Sean Lee. So it was not a deal that Mike Park was selling his shares. Mike Park was the operator, he was the experienced. Jamie Madden trusted his experience in order to decide that she wanted to invest in this business. The evidence is going to show, in fact, that Jamie Madden said, I trusted Mike Park. I was investing in Mike Park. That Mike Park is the reason why I'm making this investment. I don't know Sean Lee, but I know that he is connected with Mike Park. So if he's connected with Mike Park, I trust him. So she trusted Mike and gave her $50,000 to Sean and got 10% of the profits. Now, the evidence is going to show that Mr. Lee breached that deal with Miss Madden because he failed to provide reports. He failed to provide the 10% of profits. Her goal, her primary goal was to get that 10% of the profits now and in the future. Remember what I said in the beginning? She was not looking at this as a 2-year deal. She was thinking 12 years and beyond. So she gave $50,000, not just looking for 2 months of profits, which the evidence is going to show that Mike Park paid his share, paid the profit distributions for the months he ran the business. Miss Madden was looking for a successful business investment for the whole 12-year term and beyond. She wanted something that was going to pay her money for a long time. Now, the evidence is going to show that Sean Lee breached this agreement because he did not pay to Miss Madden for profits, and that he kept the $50,000, used it for the building, and then he took the business and never paid Miss Madden her money. Now, this gave Miss Madden no option but to go back to Mike Park and say, "What up? What's up? You introduced me to this guy. I trusted you. What are you going to do about it?" Well, the evidence is going to show that Mike Park repaid Miss Madden her $50,000. And in exchange for that repayment, he took on her rights and responsibilities. Most particularly, he ended up with her 10% and the right to sue today on her behalf. So when we talk about the claims that Mr. Park has, we're including not 50%, but 60%. So these claims are based on 60% of the profit of the business is what we are seeking. Our first cause of action is for a breach of contract. And then we're also asking for a breach of fiduciary duty. We brought a claim for fraud and misrepresentation and a claim for conversion. I'm throwing these words out here today, right now at the opening, for you to know what claims we're talking about. But the law is going to be described more by the judge at the end of this case. He's going to explain what a breach of contract is, what a breach of fiduciary duty is, what are the elements of fraud and misrepresentation, and what is the elements of conversion. I will say, however, that Georgia law does not allow me to collect more than a single dollar of damages. So I'm going to tell you what damages we're seeking. And then our goal is that you will check all the boxes that apply, that we will show you evidence that the breach of contract is valid and each one of these other causes of action is valid. And that we believe that you should be able to check those boxes and give the award of damages to Mr. Park. Now let's talk about damages. Remember, Mr. Lee did not provide any financial reports, no bank statements, no tax returns. We don't know a single thing about what he did during that 27 months. Now we've done discovery, we've asked the questions, we got no answers. So therefore we have to go on what we do know. And what we do know is what the business earned with Mike Park rate. The evidence is going to show that in January, the business had a net profit of $36,000. Month one. The evidence is going to show that in month two, the business had a net profit of $53,394. 2 months. The average of those 2 months is $44,738. 60% of that would be $26,843. So what we're looking at now is 27 months at that 26,843 number is $724,755.60. That's what we're asking for you to award to Mike Park as the damages that we are seeking for the profits not distributed. Now, we're also asking you to award $50,000 for the investment from Ms. Madden. Why? Because Ms. Madden invested that money thinking she was going to get 12 years of profits. She did not. In fact, she got 2 months of profits. She is entitled to more than just her 10%. Her claims are the 10% of what we know Mr. Lee actually did and her $50,000 back. We're also asking you to award reasonable attorney's fees. And in this situation, we're asking for attorney's fees in the amount of $65,257.05. So the total amount that we are asking you to award Mike Park today is $840,282.65. Now, the attorney's fees are going to be based on the fact that Mr. Lee has been stubbornly litigious and has put us to unnecessary trouble and expense. The judge is going to explain to you when he tells you the law what that means. But I can tell you right now that the evidence is going to show that Mr. Lee has acted in bad faith and has put us to unnecessary trouble and expense. So I ask that you listen to the evidence and listen to the look at the documents that we have. And I would ask you to award Mr. Park $840,282.65. I want to thank you for your time, your close attention, and we're going to do our best to get you out of here as fast as we can, and so that we can take care of this case and you guys can take care of your business. Thank you.
Same here on court, opposing counsel, ladies and gentlemen of the jury, good afternoon. My name is Orem Baig, and as I told you back when we were doing voir dire earlier today, I represent the defendant, Cheng-Sup Lee, also known as Sean Lee. As I mentioned to you, he is the defendant. He is also the counterclaim plaintiff. That's going to be an important point as we go on throughout the trial. So I'll do my best to keep reminding you of that fact. But what I want to start with is first and foremost, I just want to say this, and I really want everyone to understand this. Mr. Collins is an excellent attorney. He and I have been working on this case together for years. Literally, this is an older case. I've had an extremely cordial relationship with him. I think very highly of him. All of that being said, we disagree on this case. We see it very differently. And that's fine, because that's the nature of our job. It's never personal, and it's not personal. I have tremendous respect for him and his staff. But as I say that, I could not help, as he was giving his opening statement, hearing the points he was making and just thinking to myself, it's unbelievable how differently we see this. In some ways, for me, this is the ultimate case of that glass of water that's kind of halfway full. And some people see that as half full, and some people see that as half empty, but it's the exact same glass of water. And the reason I'm saying that is because we agree that there was a verbal agreement between these two men to go into business together. Completely agree on that point. We agree about the nature of the business being this game room set up in North Carolina. Again, no dispute, that was the idea. So when you start getting into, where this thing kind of goes off the rails and where the disagreements come from, I think it's very important to note something that Mr. Collins pointed out, and that is that the plaintiff in this case, Mr. Park, is a very savvy businessman when it comes to these types of operations. As he pointed out, my client is not. And that is a very important point, ladies and gentlemen. Because what you will learn today and throughout the course of this trial is that what Mr. Lee is a business person who knows how to operate within certain spaces. So what do I mean by that? If you rewind the timeline back to 2012, what you're going to hear from Mr. Lee is that at that time, he was operating a business in Korea that was very profitable. It was a Segway license, essentially, that gave him a tremendous amount of business authority in Korea to operate Segways. Everybody's, I guess, perhaps familiar with these Segways. So what that did for Mr. Lee is it gave him significant financial foothold, and it put him in the position where, I think, for a lot of folks who are fortunate enough to have disposable income, it put him in a position where he can now invest. So what Mr. Lee started to do from 2012 onward is he started to look for investment opportunities. Now, again, this is a point that I think is really important here, is that you've heard the term silent investor. Silent investor. And we've all probably heard that even before, when we're talking about movies and TV, silent investor, silent investor. So Mr. Lee had multiple opportunities to be an investor in a variety of businesses. But what does that mean? That means you can't be in every place at once. And you certainly can't live in the metro Atlanta area and commute to North Carolina every day to operate a business. And that's an important point, because it was never at any time Mr. Lee's intention to operate that business. And what you're going to hear from Mr. Lee is that he never operated that business. So again, glass half empty, glass half full. We're looking at the same thing. We're seeing it totally differently. You just heard from the plaintiff's counsel in their opening that there was somehow this flip of status. It went from, yeah, he was a silent investor, we agree, but at some point he flipped into an operational partner. You're going to hear from Mr. Lee directly. He's going to have an opportunity to take the stand and talk to you and tell you that never happened. And there's reasons why it never happened. And he's going to tell you what those reasons are. For our purposes, I think it's important that I mention at this point that Mr. Lee is a Korean national or from Korea. English is his second language. And the reason I'm telling you that, folks, is because he is going to be speaking to you throughout the course of this trial through the use of an interpreter. She's seated in the back row, and she'll be joining him when he comes to sit here at the witness stand. And so what's going to happen is he's going to receive the questions, have them translated to him. He will then repeat his answer to her. She will then translate it to you in English. Of course, his translation or his statement to her will be in Korean. So the reason I'm mentioning that is because we're going to do our best to make sure that you're getting all the information you need. But I didn't want anyone to be thrown off by the fact that he was going to be speaking to you through an interpreter. Now, as I say that, bringing it back to the points of this case, Mr. Lee is going to, when he does have the opportunity to take the stand, he's going to explain to you why that fact is important. Not only is he still getting accustomed to living in America, doing business in America, being American, he's also getting accustomed to driving. That's an important point, because as Mr. Lee will tell you, he drives locally. Sure, he was able to make it to the courthouse today, but he doesn't drive interstate. He doesn't drive outside of Georgia. So again, when you hear this evidence, you're going to understand he not only did he not become the operational partner, he didn't have the wherewithal, even if he wanted to be the operational partner, to operate a business in the state of North Carolina. His intention all along was to be the money partner. Now let's talk about that. Mr. Collins put some figures on the board, and we saw that there was a figure attributed to the investment by Mr. Lee of about $150,000. What you're going to hear from Mr. Lee when he has a chance to testify is it's actually double that amount. It's actually double that amount. And it's going to be not a lump sum, but it's going to be payments made over time for the benefit of the business. Now, anybody who's paying attention is going to have some questions. Why on earth would Mr. Lee invest that much money into this business with no paperwork, no assurances? How was it accounted for? Where was the accounting? I'm just going to tell you right now, this deal, and Mr. Lee will tell you the same thing. I suspect Mr. Park will tell you the same thing. This deal was not papered properly. This deal, nobody was represented by counsel when they went into this deal. The financials are not what you would expect to see in an actual business operation. So for a moment, we have to step outside of our kind of construct of what a proper deal looks like. We have to understand what these two men engaged in. I think in Bordier, you probably heard the term handshake deal. And if there ever was a handshake deal, it was this deal. And so it wasn't papered. It wasn't accounted for. It was not the clean deal that we would love to see. And if it was, I'll tell you what, we wouldn't be here today, right? We wouldn't be here today if that was true. So what's going to happen is you're going to be confronted with certain documents. They're not going to be clean. You're going to be confronted with certain facts that they're going to attach meaning to. You're going to get to hear directly from Mr. Lee himself, and he's going to tell you, no, those documents don't mean what they're saying. He's going to offer you those meanings. And again, this is not an opportunity for me to testify. He's going to do that, but I'm just previewing for you what we expect you're going to hear. Here's the bottom line for us, folks, is that when we look at the same scenario as the plaintiff, we see it completely differently. What actually happened, and again, Mr. Lee is going to tell you when he testifies, is that he was induced into this deal. He was promised huge returns. Anybody who has any concept of gambling rooms or gaming machines or the Georgia Lottery, and I know we talked about it ad nauseum during the Bordier process, I think we all kind of understand what kind of machines we're talking about now. If you know anything about them, and I know some of you may have even worked in these convenience stores in the past, one of the things you know is they are huge cash cows. Huge cash cows. And they drive revenue like crazy. So for someone who has experience running these rooms to make promises of, hey, $100,000 a month. I mean, you will literally hear Sean Lee tell you that. Is that was the return on investment he thought he could make by investing in this thing. Almost too good to be true. As we all know how the old saying goes, if it seems too good to be true, it's because it is. And that's really at the core of this case. Mr. Lee is out $300,000. $300,000 gone, real cash gone, because he trusted Mr. Park. He's going to tell you that he didn't just trust him out of the blue. He knew Mr. Park. Remember what I said earlier about how the evidence is going to show that he had the Segway license in Korea? That made him somewhat of a celebrity in the Korean community, in the Korean business community. And he found himself being approached all the time by people with business ideas and investment ideas. He's going to testify that he made acquaintance with Mr. Park back in 2012. They became golfing buddies. They knew each other. And it wasn't until 2019 that Mr. Park pitched this particular idea to him. So this didn't come out of nowhere. This was a build-up, a gaining of trust, a comfort level, and then to ask, put in this money, invest with me. You'll get $100,000 a month. I promise you. I guarantee you. These are the things that Sean Lee's going to tell you happen. They are looking at the same glass of water we are, and they are seeing it completely differently. And I don't know why that is. I don't know if Mr. Park has told them, because obviously Mr. Collins and I, neither of us were there. None of you were there. All we have to go by are these two gentlemen's words. This is going to be, in many regards, folks, the ultimate he said case. And your job is going to be to figure out who's telling the truth. What makes the most sense? One thing I do want to point out is you've heard reference to a Cheney Madden. Miss Madden is going to be testifying in this case, but it's going to be it's going to be unusual. She's not going to be here. We have already taken her statement or her testimony through something known as a deposition, where she was asked questions by Mr. Collins and by an attorney in my office, and she gave those answers, and we have a transcript of that. And so what's going to happen is when it's time for Miss Madden's testimony, that transcript is going to be read to you all in kind of almost a play where the attorneys will take turns reading the attorney lines, and then somebody from the staff will take turns reading Miss Madden's lines. So I wanted to preview that for you, because that's another kind of unusual way that you'll be hearing some testimony. But here's the thing that I want to tell you about Miss Madden's testimony. Mr. Collins is right. I think we, again, both agree that Mr. Park had the relationship with Miss Madden. You're gonna hear from Mr. Lee. He doesn't know who Miss Madden is. He almost couldn't even pick her out of a lineup if he had to. Met one time, and that was to sign on some paperwork that Mr. Park suggested that they sign. And Mr. Park essentially orchestrated this $50,000 cash infusion into the business. It wasn't a loan. It was an investment, and she was getting 10%. But it wasn't going to Sean Lee. Sean Lee wasn't getting $50,000. Sean's gonna testify that $50,000 went straight to the business. Oh, and speaking of the business, when you have a 50-50 partnership, I understand, they want you to think that Mr. Park was this, game room wizard and he has this operational skill and he's gonna get this company going and they're gonna make cuckoo bucks. So therefore, he doesn't need to put any money in. You put all the money in, Sean. That's what essentially the deal is if you listen to the plaintiff. Now, here's the problem. Sean kept putting money in, and he kept putting money in, and he kept putting money in, and then ultimately, no money came from Mr. Park. Why is that important? That big dollar amount that you saw on the board, almost $900,000 that they want you to award Mr. Park against Mr. Lee, none of that was a dollar that left Mr. Park's pocket. Mr. Park did not outlay almost $900,000. That is what we call speculative damages. That is money that he thinks he could have made if Mr. Lee had somehow done something that he thinks Mr. Lee should have done. But that's not money that left his pocket. That's a very important point. $300,000 left that man's pocket, but not Mr. Park's. So please keep that in mind as the evidence is presented. Who lost what? That is the question for you as a jury. Thank you for your time. We look forward to being able to show to you that not only is Mr. Lee not liable to Mr. Park, but in fact, Mr. Park is liable to Mr. Lee. Thank you.
All right, members of the jury, before we get into the evidence, one other logistical thing I forgot to mention, which is at any point, if anything's distracting you, you need a break, quick bathroom break, just raise your hand. We want to make sure that everything you get in here gets your undivided attention. Even if it's in the middle of testimony, just raise your hand and we'll just go off your guidance for when we need to take breaks. Otherwise, we'll plow ahead. So at this point, plaintiff may call their first witness.
Your Honor, we'd like to call Sean Lee to the witness stand.
All right.
This is a cross-examination.
Understood.
Thank you.
And so which of our interpreters is going to be taking point here? And Deputy Scott, I'd ask if you could roll one of our other chairs up here, maybe to the side of the screen there.
Exhibits.
Yes.
All right, ma'am. And while we're finding you a seat, if we could just have you state and spell your name for the record.
SarahyoojOung, last name Park.
All right. And Ms. Park, do you solemnly swear or affirm that you'll faithfully interpret from Korean into English and from English into Korean the proceedings before this court in an accurate manner to the best of your skill and knowledge?
Yes.
Thank you, ma'am. All right. And again, hold tight. We'll hopefully have a place for you to sit in just a moment. And while we're doing that, actually, Mr. Lee, if you could raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thank you. You can have a seat. And Mr. Lee, even though we have an interpreter, no need to whisper. You can speak up.
협사가 있지만 속삭이실 필요는 없고요. 필요하신 대로 말씀하시면 되겠습니다.
네, 알겠습니다.
Okay, I understand.
All right. So we might want to make sure we lean into the microphone.
말씀드리겠습니다.
All right. And with that, Mr. Collins, your witness.
May I approach, Your Honor, have the trial notebook?
You may.
Please state your name for the record.
성함을 말씀해 주십시오.
장섭 샨리입니다.
창섭 션 리.
Where do you work now?
어디에서 일하고 계십니까?
저는 지금 커밍에서 브루스터 아이스크림집을 운영하고 있습니다.
Currently I own a Brewster ice cream in Cumming area.
Your Honor, would like to ask that they speak Korean into the microphone as well so that my client can understand what they're saying.
Okay, again,
마이크로 한국말을 말씀해 주시면.
네.
Okay.
Do you own any other businesses other than the Brewsters?
브루스터스 아이스크림 외에 다른 비즈니스 운영하시는 게 있으십니까?
없습니다.
No.
And do you have any other jobs or employment other than operating the Brewsters?
브루스터스 운영하시는 거 외에 다른 하시는 일들이 있으십니까?
그냥 스탁 같은 거 하고 뭐 딴 거는 없습니다.
Nothing else, just buying stocks,
코인 같은 거.
coins.
And where did you work before you bought the Brewsters?
브루스터를 하시기 전에 어디에서 일하셨습니까?
많은 데서 인베스트를 많이 했습니다.
I invested in many different areas.
Okay. Now, you had a partnership with Mike Park. Is that correct?
마이크 박 선생님과 파트너십이 있으셨습니다. 맞습니까?
네.
Yes.
And that was to operate the 210 skill sweepstakes business, correct?
투텐 스킬 스테이크 그 비즈니스를 같이 운영하셨습니까?
네.
Yes.
And did you work with Mike Park on any other kind of business deal before this 210 skill sweepstakes?
투텐 스킬 스윕스테이크 전에 다른 비즈니스를 마이크 박 선생님과 하신 적 있으십니까?
없습니다.
No.
But you knew Mr. Park beforehand, right?
하지만 박 선생님을 그 전에 아셨습니다. 맞습니까?
네.
Yes.
I believe it has been mentioned that you were golfing buddies with Mr. Park. Is that an accurate way to describe your relationship?
박 선생님과 전에 골프를 같이 치는 친구라고 앞서 이야기가 나왔는데 그렇게 말해도 되겠습니까?
네.
Yes.
Did you ever have any kind of partnership arrangement with Mr. Park prior to the 210 skill sweepstakes?
투텐 스킬 스테이크 회사 전에 두 분이 파트너십이 있으셨습니까?
없습니다.
No.
How did you learn about Mr. Park's experience in skill gaming?
어떻게 알고 계셨습니까?
저 사람이 와서 저한테 뭐 돈을 많이 번다, 뭐 10만 불을 번다, 뭐 한 달에 10만 불을 번다고 계속 얘기해서 그래서 뭐 알게 됐습니다. 그러니까 저 사람이 저한테 어프로치를 먼저 했습니다.
He approached me first. In many ways, he explained it to me how through this business that he gains $100,000 per month. He approached me many times with it.
Okay. And when you say he approached you, was he talking to you about investing?
어프로치를 하셨다는 단어를 사용하셨는데 그 말은 투자를 해달라고 말씀하셨다는 말입니까?
네.
Yes.
Okay. So ultimately you decided to become partners, right?
그러면 그 이후에 투자를 하시기로 결정을 한 거네요.
네.
Yes.
In fact, y'all agreed to start off as 50-50 partners, right?
시작을 하셨을 때는 투자를 50대 50으로 하는 걸로 시작을 하셨고요.
네. 그러나
Yes, but
돈을 넣는다고 반을 넣는다고 그랬는데 저 사람은 한 번도 넣은 적이 없습니다.
he said he will invest the half, which was the half portion, but he never invested any of the amount.
Okay. Did you commit to invest up to $150,000?
15만까지 투자하시는 거를 서로 agree 하셨습니까?
아니요. 처음에는 10만 불밖에 안 된다고 저한테 얘기했는데 그리고 나머지는 자기가 한다고 그랬는데 자기가 돈이 없다고 계속 돈을 투자를 안 했습니다.
At first, he only asked me to invest 100,000, but later he told me that he will invest the rest. But in the future, he will keep telling me that he didn't have enough money to invest, so he asked me to invest more.
돈을 한 1불도 안 넣습니다.
He never invests even $1.
Did you have any experience in operating a skill gaming business?
스쿨 게이밍 그거를 운영하신 적이 있으십니까?
전혀 없습니다.
No, never.
And you knew and understood that Mr. Park did have that experience, right?
하지만 이해하신 대로라면 박 선생님께서는 그런 것을 운영할 수 있는 능력이 있으셨습니다. 맞습니까?
네, 자기가 전문가라고.
Yes, he told me he was the expert.
Okay, and so y'all decided to be 50-50 partners with you as the investor, right?
그러면 50대 50으로 하게 하면서 본인은 투자자로 합류를 하신 겁니다. 맞습니까?
같이 투자를 하기로 했는데 투자를 저 사람은 안 했습니다.
Again, we were supposed to invest together, but he didn't invest any.
But the agreement was that Mr. Park would be the operator, that he would operate the business, right?
두 분이 동의하신 대로라면 박 선생님께서는 그 비즈니스를 운영하시는 거였습니다. 맞습니까?
그렇죠.
Yes, correct.
그렇죠.
This was because Mike Park was the guy with a lot of experience in running the skill game business, right?
마이크 박 선생님께서 이 스킬 게임을 하는 능력이 있으셨기 때문에 같이 동업을 하시게 된 거죠.
네,
Yes.
So as the operations partner, Mike Park would be responsible for finding a location for the store, right?
그러면 같이 운영을 하고 동업을 하는 파트너로서 박 선생님께서는 그 비즈니스가 세워질 장소를 결정하고 물색하는 역할을 하셨습니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
And in fact, Mike Park did find the location in North Carolina on Highway 210, right?
또 마이팍 선생님께서는 노스캐롤라이나에 있는 하이웨이 210에서 장소를 찾았습니다. 맞습니까?
네, 맞습니다.
Yes.
And then Mike Park, as the expert, was also going to choose what games to put in the store.
마이팍 선생님은 전문가로서 어떤 게임을 거기에 집어넣을 건지를 또 선택하셨습니다. 맞습니까?
네,
Yes.
In fact, Mike Park did choose what games would go into the 210 skill store.
그리고 마이팍
Right.
선생님께서는 210 스킬 그 가게에 들어가는 게임을 선정하셨습니다. 맞습니까?
맞습니다.
Yes, correct.
Then Mike Park also was responsible for choosing the retail management systems, correct?
그리고 그 운영하는 매니지먼트 시스템을 박 선생님께서 결정하셨습니다. 맞습니까?
네, 저 사람이 다 운영하기로 했습니다.
Yes, he said he will solely operate the business.
Okay. And in fact, Mike Park did choose the retail management systems and installed them in the store, correct?
그러면은 그 매니지먼트 시스템 자체를 박 선생님께서 정해서 설치하셨습니다. 맞습니까?
네, 맞습니다.
Yes.
And Mike Park would be responsible for finding the financial reporting systems for the store, right?
그리고 재무적으로 리포팅을 할 수 있는 그 시스템도 박 선생님께서 선별하셨습니다. 맞습니까?
네, 맞습니다. 그러나
But
그 서류를 지금 여기서 본 서류랑 이렇게 주지 않았습니다.
yes, but those financial document never looks like ones that is front of me.
Okay. Isn't it true though that Mr. Park sent you QuickBook reports that show the finances of the business?
박 선생님께서 그 비즈니스의 재무 관계를 보여드리는 퀵북을 보내드린 적 있습니까?
없습니다.
No.
In fact, didn't Mr. Park send you reports for the 2 months that he ran the business in January and February of 2020?
2020년 1월 그리고 2월에 운영하셨던 재정 부분을 기록을 선생님께 2달치를 전달하셨습니다. 맞습니까?
전달을 한 적도 있고 안 한 적도 있고 그게 그러니까 매일 보내준 게 아니라 해주고 안 된 적도 있습니다. 그러나
I wasn't.
자기가 해주고 싶을 때만 보내줬습니다.
It was depending on when he wished to give it to me. It wasn't like everyday regular report. He will sometime give it to me, then he will skip it. So it wasn't regular report.
But you did get some financial reports though.
하지만 재무에 관련된 레포트를 받으신 적은 있습니다.
네,
맞습니까?
있습니다.
Yes, I have.
And so Mike Park was also responsible for developing marketing systems for the store, right?
그리고 그 가게에 마케팅을 하고 광고를 하는 부분을 박 선생님께서 맡아서 하셨었습니다. 맞습니까?
네, 저
Yes.
사람이 다 운영을 했습니다.
Yes, he operated everything.
Okay. And he did in fact institute marketing programs that draw players into the store, right?
또 마케팅 프로그램을 통해서 다른 사람들이 그 게임을 하도록 오는 것들을 다 유치했습니다. 맞습니까?
네, 맞습니다.
Yes, correct.
Right. And did you sign the lease for this property?
건물의 리스를 본인이 계약하셨습니까?
네, 맞습니다.
Yes, that's correct.
Okay. I want you to open the binder if you want to go to tab number 3. I want
한번
to show you the lease agreement.
이게 리스 계약서입니다.
If you would look at the pages of the lease agreement,
페이지를 좀 보시고
please confirm that this is a true and accurate copy of the lease agreement.
이게 리스 계약서의 정확한 사본인가요?
네, 맞습니다.
Yes, that's correct.
Your Honor would like to tender exhibit 3 into evidence.
한번 자료를
minute.
증거 자료로 전달하겠습니다. 예, 받겠습니다.
And as you see at the top of this lease agreement, it's dated September 1, 2019. Is that correct?
9월 1일 2019년으로 명시가 되어 있습니다. 맞습니까?
네, 맞습니다.
Yes, correct.
And it's between Blackman Property Group LLC and SM Min LLC Enterprise. Is that right?
보시면 Blackman Property Group LLC와 SM민 LLC Enterprise로 되어 있는데요.
네,
맞습니까?
맞습니다.
Yes, correct.
So even though that is sort of the words are out of order, that is the company that you and Mr. Park operated, right?
네, 뭐 명시되어
SMN
있는
LLC
순서는 다르겠지만 두
Enterprises
분이 함께
LLC.
운영하셨던 게 SM민 LLC Enterprise가 맞습니까?
SM인 엔터프라이즈인데
네.
마이크 팍 저 사람 이름은 없습니다. 저 사람은 이 회사 이름이 없습니다. 투자를 안 했기 때문에 이 회사 이름이 없습니다.
His name is not included in SMmin LLC Enterprise because he didn't put any money in. So again, his name is not part of this company.
But at the time that this lease was signed, it was signed as the partnership between you and Mr. Park, right?
하지만 이 계약서를 서명하셨을 때는 두 분의 동업자께서 같이 동업을 하신다는 내용으로 서명하신 거 아닙니까?
그런 내용으로 서명을 했는데 돈을 계속 안 넣어서 이 사람이 돈을 넣으면은 이 SM인 여기다가 이름을 넣기로 했는데 여태까지도 돈을 안 넣습니다.
We stated that once he invests the money that he will become part of SMmin LLC Enterprise, but he never did until today. So he's not part of the company.
If you go to the next to last page, is that your signature?
마지막 페이지로 봐주시고요. 이게 본인의 서명하신 거 맞으십니까?
네, 맞습니다.
Yes, that's correct.
And were you present when Ms. Lupton signed?
럽튼 씨께서 서명을 하실 때 그 자리에 계셨습니까?
네, 맞습니다.
Yes, correct.
Did you negotiate the terms of this lease?
이 계약에 관련된 내용을 내고하셨습니까?
아니요. 마이크 박했습니다.
No, Mike Park did.
So Mr. Park negotiated the terms of the lease, the landlord put it together, then you signed, right?
그러면은 박 선생님께서 세부적인 사항을 논의를 하시고 나서 럽튼 측에서 준비를 해준 거를 선생님께서 서명하셨습니다. 맞습니까?
네, 왜냐하면 저 사람 이름이 왜 안 들어갔냐면 저 사람은 이 회사의 그 파트너가 아니기 때문에 저 사람 사인이 여기 안 들어가 있습니다.
Because he was not the partner of the company, his name was not on the document. That's why I signed.
Okay. But this lease was negotiated by Mike Park and then put together by Blackman Property Group, and then you signed on behalf of the company, correct?
그러면 마이크 박스 선생님께서 세부 사항을 내고하시고 결정하신 후에 블랙몬에서 이 서류를 준비를 하고 그리고 선생님께서 서명을 하신 겁니다. 맞습니까?
서명을 할 때는 전적으로 저의 책임이었지 저 사람 책임은 하나도 없었기 때문에 저 사람은 여기 리스에 들어가 있는 그게 없어요.
Once again, he was not part of the lease and the whole responsibility was on me and that's why I signed it.
Okay, let's look at exhibit 4.
4번을 봐주시겠습니다.
Is this a true and accurate copy of a estimate for Glasgow Design Build that you provided to us during discovery?
글래스고 디자인 빌드에 저 있었던 디자인 관련된 그 디스크립션 빌링을 저희 측에 보내주는데요. 그 사본이 맞나요? 정확한 사본이?
이거는 그냥 에스티메이트지 정확한 이대로 그 계약한 건 없습니다. 이거는 그냥 견적만 띈 거고.
This was the estimate and it was only a quote, so this was not part of exact contract.
Right, but this is a document, this is a true and accurate copy of the document you provided to us, right?
하지만 본인께서 저희 측에 제공하신 서류 사본 맞습니다. 맞죠?
제가 이거를 제가 기억이 안 나는데 이거를 회사를 연락한 사람은 저 사람이지 제가 아닙니다. 이거를
I don't quite remember who request or contact Glasgow Design Bill. Must be him, not me.
저는 아닙니다.
Not me.
Did you ever see this? Have you seen this document before?
이 서류 보신 적 있으십니까?
본 적은
Yes.
있습니다.
Yes, I have.
Did you get this you had this prior to the lawsuit though, right?
소송하시기 전에 이 서류를 갖고 계셨습니까?
기억이 잘 안 납니다.
That I
이거를
don't quite remember.
제가 견적을 띈 게 아니라 저 사람이 견적을 틴 거라서
Quote,
기억이 잘 안 납니다.
quote was received by Mr. Park, so I don't remember.
The date of this is August 23rd, 2019, right?
2019년 8월 23일로 명시되어 있습니다. 맞습니까?
네네.
Yes.
This is after you and Mr. Park had formed your partnership, right?
그리고 두 분이 동업을 하시기로 결정하신 후의 내용이지요.
네.
Yes.
And it
네.
says to Mr. Sean Lee at the top. It's got your name on it, right?
보시면 본인의 이름이 위에 있는데요. 맞습니까?
왜냐하면 저 사람은 이 회사에 아무 관련이 없었기 때문에 전부 다 제 이름이었어요. 제가 리스폰시블 다 갖는 거고 저 사람은 책임이 하나도 없었어요.
I was responsible for all the business operation when it comes to these type of document, and that's why he used my name. But because he wasn't able to represent this company in any way, that's why my name is on there.
So did you talk to Glasgow Design Build about
그럼
this estimate?
본인께서 글래스고 디자인 빌드하고 이야기를 직접 하셨나요?
없습니다. 저
No,
사람이
never
있습니다.
have. He did.
Mr. Park talked to Glasgow Design Build.
그러면은 박 선생님께서 글래스고 디자인 쪽하고 얘기하셨다고
네,
말씀하시는
네,
거죠?
네.
Yes.
Okay, but you have seen this estimate, this $50,000 estimate before, right?
하지만 이 금액을 명시한 콧을 보신 적 있습니다. 맞습니까?
있습니다.
Yes, I have.
Let's look at Exhibit 7.
7번을 보시겠습니다.
This is also an estimate from Glasgow Design Build. Have you seen this document before?
이것 또한 글래스고 디자인 빌드에서 나온 콧인데요. 보신 적 있으십니까?
예, 본 적은 있는데 그냥 코트만 했지 하지는 않았습니다.
I have, but once again, this is just a quote. Didn't
Right.
do anything with it.
Right, so the work, was this company hired to perform any kind of renovation work on the business?
이 비즈니스 운영하시는 거에 제 그 레노베이션 하는 거를 이분들에게 맡기셨던 거 아닌가요?
아닙니다.
No.
Okay, now this estimate is for substantially more than the estimate we just looked at, isn't it?
바로 전에 보셨던 서류보다는 금액이 굉장히 높은데요. 맞습니까?
네, 맞습니다.
Yes, that's correct.
Okay, and in fact, after you and Mr. Park received this estimate, isn't it true that you went back to Glasgow and asked them to narrow the scope of work to lower the cost?
두 분께서 박 선생님 측과 함께 이 금액을 보시고 금액이 너무 크기 때문에 이 금액이 설명하는 거를 세분화해서 달라고 직접 연락하시지 않으셨나요?
저는 안 했습니다.
I didn't.
Okay, but did you and Mr. Park talk about doing that as a cost management strategy?
하지만 박 선생님과 함께 금액을 줄이고자 돈이 들어가는 지출을 줄이고자 그런 논의하신 적 없으십니까?
뭐 지출을 이거는 기억이 안 나는데 줄이하자고 비즈니스 하다가 논의한 거는 많죠. 그러나 이거는 잘 기억이 안 납니다.
There have been a many occasions that we will talk about how to save a cost on when it comes to operating the business, but I don't particularly remember on this one.
Okay, do you recall talking to Mr. Park about a desire to lower this cost from 100,000 to 50,000?
10만 불 금액 그 5만 불 정도로 줄이는 거를 박 선생님 측과 논의하신 적 없으십니까?
이 10만 불을 어떻게 5만 불로 줄입니까?
How is it possible to bring it down from 100,000 to 50,000?
But didn't you talk to Mr. Park about narrowing the scope of work to be done to lower that cost?
박 선생님과 한 번이라도 일을 줄여서 해야 되는 일을 줄여서 들어가는 금액을 줄이자라는 내용을 좀 논의하신 적은 없으십니까?
기억이 잘 안 나지만 이 케이스는 잘 기억이 안 납니다.
I don't remember regards to this case.
Your Honor, I talked to opposing counsel. We're going to stipulate to the admission of exhibit 4 and 7. If that's okay, we'd like to have these two documents admitted.
All right, if you could just identify those two exhibits for the record.
For the record, we're asking to admit exhibit 4 and exhibit 7.
동의를
I mean, what they are.
Oh, exhibit 4 is the Glasgow Design Build Estimate dated August 23rd, 2019. The second document is exhibit 7. That is the Glasgow Design Build document dated July 12th, 2019.
Any objection?
No, please.
They're admitted.
양측에 무리가 없다면 전달하겠습니다.
So if we look at that exhibit 7,
1번을 보시고요.
the dollar amount on that initial proposal was for 105,173.43. Is that correct?
10만 불 5,173불 43센트인데요. 맞습니까?
네, 맞습니다.
Yes, that's correct.
And so then you look at exhibit 4,
4번을 보시고요.
and the total project cost and the estimate for exhibit 4 is 52,899.
4번에 보시면 52,899로 되어 있습니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
And do you recall talking about the two proposals with Mr. Park?
박 선생님과 두 개의 콧을 가지고 논의하셨던 기억이 있으십니까?
잘 기억이 안 납니다.
I don't remember.
Okay. Do you remember why you decided not to use Glasgow for the construction work?
글래스고우에서 그 일을 맡기지 않기로 결정하신 부분에 대해서는 혹시 기억하십니까?
기억이 안 납니다.
No, I don't remember.
Next, let's go to exhibit 1, if you will.
1번으로 가주시겠습니다.
Okay? You identify this document?
서류 아시겠습니까?
네, 압니다.
Yes, I know. I'm aware of this.
Okay? Is this a true and accurate copy of the check that you received from Ms. Madden?
미스 메린에서 전달받으신 정확한 수표 사본
네,
맞습니까?
맞습니다.
Yes, that's correct.
Your Honor would like to tender exhibit 1 into evidence.
No, please.
It's submitted.
Okay? What is the date of this check?
체크의 날짜가 언제로 되어 있지요?
12월 16일 2019년도입니다.
2019 December 16.
And who is the check made payable to?
그리고 payable to가 어디로 되어 있지요?
저입니다.
Myself.
Okay? And what is the dollar amount of this check?
금액이 어떻게 되지요?
5만 불입니다.
50,000.
Who signed it?
가 서명했지요?
이거 제가 이 사람이 있었고 뭐 이거 저를 줬고 제가 쓰지는 않았습니다. 이 사람 이 여자가 썼습니다.
Miss Madden wrote it. I didn't wrote it. I just received the check.
And what is the for, where it says for on the bottom of the check? What does it say there?
무엇을 위한 거라고 되어 있지요?
210 스케일 스케일 써져 있어요.
210 scale, but 210 scale something.
And was that your understanding that that was for the investment in the business you had with Mr. Park?
박 선생님과 함께 하시는 비즈니스의 투자 금액으로 이해하셨습니까?
박 선생 저 사람이 투자한 게 아니라 이 여자가 투자한 겁니다.
No, it was investment that was made by Miss Maiden.
So, had you met Miss Madden before she gave you that check?
체크를 받으시기 전에 매든 선생님과 만나신 적 있으십니까?
없습니다. 이게 처음 만나고 그 다음에 한 번도 만난 적이
This
없습니다.
was the first and last time I encountered with this person.
Where did you meet her?
어디서 만나셨나요?
은행에서
At the
만났습니다.
bank?
What bank was this?
어떤 은행이었죠?
그게 뱅크 오브 아메리카.
Bank of America?
Was that her bank or your bank?
그 여자분의 은행이셨나요? 본인께서 이용하신 은행이었나요?
그 여자도 있었고 이걸 공증을 받으러 간 거라서 그 아무은행이라 갔는데 그 여자가 CNS 뱅크 오브 아메리카에 구자가 있다고 그래서 그걸로 갔습니다.
We needed to have a notarized, so we just went to a random bank and it was a Bank of America because she told me she had an account there.
Okay. Did you deposit the check while you were at the bank or cash the check?
은행에 계실 때 이 체크를 디파짓 하셨거나 캐시아웃 하셨나요?
아니요, 이거 나와서 이 뱅크에다 안 하고 딴 뱅크에다가.
No, I deposited into a different bank after I left the place.
So you left the Bank of America and then deposited the check?
그러면은 그 은행에서 나오셔서 다른 데 가셔서 체크를 디파짓 하셨다는
네,
말씀이시죠? Yes.
Where did you deposit the check?
체크를 어디에 디파짓 하셨나요?
그 제 은행 어디다가 디파짓했는지 기억이 잘 안 나는데 근데 제 은행에다 디파짓했습니다.
It was to my bank, but I just don't remember where it was.
Okay. Was it nearby?
근처였나요?
네.
Yes.
그리고 그날 바로 안 했습니다.
I didn't deposit that day.
Okay. Yeah, because I'm trying to get a feel for the timeline. So you went to the bank, not to deposit the check, you went to the bank to sign and notarize the second document, the agreement.
그럼 말씀하신 대로라면 처음에 은행에 가셨던 거는 디파짓을 하시러 간 게 아니라 서류에 노드리를 받으러 같이 가신 거죠?
네, 노러리 때문에 간 거예요.
Yes.
책을. 그 여자가 노트라이를 받기를 원했다고 저를 잘 모르니까 그래서
She requested that since she doesn't know me, that she wanted it to have a notarized, so we went to the bank together and received it.
Okay, so let's look at exhibit 2, please.
2번을 보시겠습니까?
Is this an accurate copy of the agreement that was signed
그
by you and Ms. Madden?
서명되고 했던 내용이 맞을까요?
네, 맞습니다.
That
네,
is
맞습니다.
Your Honor would like to admit exhibit 2 into evidence?
이번 자료를
Exhibit
증거
2 is
자료로
admitted.
전달하겠습니다. 의의 없습니다.
네,
채택되었습니다.
This agreement is between you and Ms. Madden, correct?
이 서류는 선생님과 그리고 미스 매든에 관련된 서류 계약서입니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
And you wrote this document, didn't
그리고
you?
본인이 이걸 쓰셨습니다. 맞습니까?
네, 이걸 어떻게 쓰라고 저 사람이 미스터 박이 가르쳐 줬습니다. 어떻게 쓰라고.
Mr. Park taught me how to draft this, so I did.
Okay. And so, you scroll down just a little bit. Is this your signature where it says Sean Lee, comma, president?
여기에 보시면 이 서명 본인이 하셨습니까?
네,
Yes.
제가 했습니다.
And did Ms. Madden sign this also in front of you?
그리고 미스 매든께서도 보시는 서명을 본인 앞에서 하셨습니까?
네, 네.
Yes.
Okay, and if you scroll down just a little bit more, this is the notary sign, is that right?
이거는 노르리가 서명한 거죠?
네, 맞습니다.
Yes, correct.
So let's scroll back up to the top. I just want to go through. So this is also dated December 16th, 2019, right?
12월 16일 2019년으로 되어 있는데요. 맞습니까?
네, 맞습니다.
Yes.
So this was signed right at the same time that Ms. Madden gave you the check, right?
그러면은 미스 매든께서 체크를 주실 때 이 서류도 서명한 겁니다. 맞습니까?
네, 한 날짜에.
Yes, in one day.
Okay, and so pursuant to the terms of this agreement, the 210 skill sweepstakes is given 10% of its shares to J.S. Madden. That was your intent, is that correct?
그럼 말씀하신 대로라면은 그 체크를 받고 10%의 쉐어를 최 S 매든 씨에게 양도하신 겁니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
Okay, and then in addition to the 10% shares, 210 skill sweepstakes will pay 10% of future profits to Ms. Madden, is that
그리고
correct?
말씀하신 대로라면은 그뿐만이 아니라 추후에 그 발생하는 수익의 10%를 또 주기로 했습니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
잠깐만요.
Hold on just a second.
기본 10% 쉐어를 주고 프로핏 주고 예, 맞습니다.
Share and profit 10%, 10%.
맞습니다.
Yes, that is correct.
Okay, and I think when you met with Miss Madden, she was very focused on the 10% of future profits. Is that correct?
매든 선생님하고 만나셨을 때, 후에 발생되는 수익의 10%를 받는 것을 굉장히 중요하게 말씀하셨습니다. 맞습니까?
네, 맞습니다.
Yes, that's correct.
And the $50,000 that you got from Miss Madden, that money was used to finish the renovation of the store, right?
그 5만 불 받았던 체크로 가게 레노베이션을 하는데 필요한 돈을 메꿨습니다. 더 냈습니다. 맞습니까?
뭐 레노베이션이라기보다도 그 뭐 어디에 썼는지 모르겠지만은 이 돈을 가게에는 썼습니다.
I don't know if it was just for renovation, and I don't know exactly what it was for, but it went into our operating fund.
Okay. Let's go to exhibit 5.
5번을 살펴보시면.
This is a document that you provided to us during discovery. Is this your handwriting?
상층에서 제출해 주신 자료인데요. 본인의 뜻가 맞습니까?
네, 맞습니다.
Yes, that's correct.
Is this an accurate copy of the document you provided to us during discovery?
저희 측에 제출하신 정확한 사본입니다. 맞습니까?
네, 맞습니다.
Yes, correct.
Your Honor, would like to admit exhibit 5 into evidence.
이번엔 증거
Submitted.
자료를 전달하겠습니다.
So is this a list of expenses that you say that you paid for the business?
이게 본인께서 생각하시는 본인이 지불하셨던 비즈니스 운영에 들어갔던 비용들입니다. 맞습니까?
네, 부분적으로.
Yeah, just portion of it.
Okay, so for instance, line 1 says computers, $500 times $150,000.
처음에
Right.
보시면 컴퓨터를 500불 100개에서 5만 불 맞습니까?
네, 맞습니다.
Yes, correct.
You did not provide any receipts to us for these computers. Isn't that true?
컴퓨터에 관련된 영수증은 저희들에게 제출하지 않으셨습니다. 맞습니까?
네, 맞습니다.
That's correct.
Where are those computers now?
그러면 그 컴퓨터들은 다 어디 있지요?
그 위쪽으로 있겠죠. 지금은 저는 어디 있는지 모르겠습니다.
It should be
저기 뭐
거기 어디죠?
노스캐롤라이나 쪽에 있겠죠. 잘
Witness
모르겠습니다.
said up. So interpreter asked, what do you mean by up? He said North Carolina, but I don't know where it is.
You're saying, he said he doesn't know where it is?
No.
Okay, you don't know where the computers are?
컴퓨터가 현재 어디 있는지 모르신다는 겁니까?
네, 모릅니다.
No.
Okay. The next line is screens. $250 times 100 is $25,000 screens. Is that correct?
스크린을 250불에 100개에서 25,000이라고 쓰셨는데 맞습니까?
네, 맞습니다.
Yes, correct.
And you did not provide any receipts for those either, right?
근데 이거 영수증을 저희들한테 안 주셨습니다. 맞습니까?
네, 영수증이 없습니다.
Yes, I don't have a receipt with me.
Where are those screens now?
그러면 그 스크린들은 다 어디 있죠?
똑같이 그 가게에 있겠죠.
I
저는
mean, it's
모릅니다.
like same. It should be at the store.
Okay, is the store still open?
가게가 아직도 오픈되어 있나요?
잘 모릅니다.
I don't know.
So we'll come back to that in a few minutes. But continuing down this list, chairs showing $60 each times 100, $6,000 in chairs. Did you buy those chairs?
의자도 60불에 100개 해서 6,000불인데요. 그 의자를 본인이 사셨나요?
네, 제가
Yes,
샀습니다.
I bought it.
But you also don't have receipts for the chairs, right?
네, 영수증이 없으시네요.
네, 이게 그 와이프가 무슨 아마존에서도 사고 뭐 여기서도 사고 그래서
My wife purchases through Amazon and different channels, so
그래서-
I don't have the receipt.
없습니다.
Okay. And then desks, $100 each for 100 desks is $10,000.
책상도
Right.
100불에
네.
100개에서 만
네,
불.
네,
Yes, correct.
And you don't have receipts for that either, correct?
그것도 영수증
네,
없으시고요.
없습니다.
No, I don't have it.
Line 7 says expense, hotel, gas, food, $10,000.
expense라고 하시고 호텔 게스트 뭐 가스 음식 해서 만 불을 하셨는데요. 맞습니까?
이거보다 더 들었는데 그냥 이 정도 썼습니다.
This is estimate and actually actual amount is way higher than this.
This is for expenses you incurred for you to stay in North Carolina, right?
이거는 본인께서 노스캐롤라이나에 계실 때 들어갔던 비용들을 계산하신 건가요?
아닙니다. 마이크 파악이랑 가서 마이크 파악 호텔에 있거나 그럴 때 같이 가서 있을 때나 그럴 때 썼습니다. 저
No.
사람은 돈이 없었기, 그걸 한 푼도 안 넣었기 때문에 제가 이런 익스펜스를 다 썼습니다.
No, he didn't pay a dollar. He didn't pay at all. So this was the expense when we were together in North Carolina. Our stay at a hotel, the expense that occurred from that, I paid for everything.
So are you saying that this is startup costs?
그러면 이게 비즈니스를 시작하는 스타트업 코스트라고 말씀하시는 건가요?
그 전에 뭐 노스캐롤라이나를 가고 뭐 자기 장소를 구한다 가고 뭐 이럴 때 거기서 호텔을 있어야 된다 그러면 제가 돈을 주거나 아니면은 그 가는 그런 비용들, 그러니까 부수적인 비용들을 그냥 제가 이렇게 다 돈을 냈습니다.
These were the miscellaneous items that whenever he requested that he need to go to North Carolina to look for a location for the business or anything related to the start of the business, he requested to me, and since he couldn't pay for it, I paid.
But you went to North Carolina also, didn't you?
근데 본인도 같이 노스캐롤라이나에 가셨습니다.
네,
맞습니까?
갔는데 저는 운전을 잘 못해서 제가 운전한 적은 한 번도 없습니다.
No, but because I don't know how to, I don't know how to drive, I never once drove.
아니야, 그게 아니라 하웨이는 잘 못해서 저 사람이 다 운전을 했지 저는 한 번도 운전한 적이 없습니다.
I'm not good at driving on the highway, so it was always him who drove me, not me.
Okay. So you've been to North Carolina, you just didn't drive to North Carolina.
본인이 그러면 노스캐롤라이나 운전을 안 하고 가셨다 뿐이시지 노스캐롤라이나에는 가셨습니다.
예,
맞습니까?
간 적
Yes.
있죠. 예.
Yes, I have.
네네.
So you look at line 8, it says TV $300 times 8, $2,400. Is that correct?
300짜리 TV 8개 2,400불 맞습니까?
네, 맞습니다.
Yes, correct.
Okay, again, there are no receipts provided for that, right?
저희들에게 영수증을 주시지 않습니다. Yes, I don't have it.
You know where the TVs are?
TV는 어디 있나요?
똑같은 문제인데 거기 있겠죠. 거기 저기 노스캐롤라이나 그 게임장에 있겠죠.
It must be their North Carolina gaming place.
Okay. Number 9 says starting money $30,000.
네, 스타팅 머니 3만 불이라고 써 있습니다. 맞습니까?
네, 맞습니다.
Yes.
Is that cash that you put into the business for initial operations?
이게 비즈니스를 시작하시기 위해서 본인이 넣으신 돈인가요?
네.
Yes.
The line 10 says adapter and mop, etc., $10,000.
아답터와 맙 그리고 해서 10,000 불 맞나요?
네, 네.
Yes.
Do you have any receipts for this $10,000 mop?
영수증 있으신가요?
없습니다.
No.
Okay. What is the adapter?
아답터는 뭔가요?
무슨 소리가 안 난다고 소리를 많이 내야 된다고 저 사람이 얘기를 해서 그거를 오다를 해달라고 그래서 그거를 또 한 100개인가를 또 사서 보내줬습니다.
He requests me that sound needs to be louder from the game. So he requests me about 100 adapters. So from his request, I purchased for him and gave it to him.
So the renovations were completed shortly after you got the check from Ms. Madden, right?
체크를 미스 매든 씨에서 받으시고 나서 레노베이션이 곧 끝났습니다. 맞습니까?
그 전에 끝났습니다.
It was finished before.
Okay. And so the store opened at the end of December.
그럼 12월 말에는 가게가 오픈됐습니다. 맞습니까?
네, 맞습니다.
Yes, correct.
And when it opened, Mike Park was running the store.
그럼
Right.
오픈했을 때는 박 선생님께서 운영을 하셨습니다. 맞습니까?
네, 맞습니다.
Yes, correct.
Okay. And you got a check for January and February for your profit share when Mike ran the store, right?
마이크 선생님께서 운영을 하시고 1월 그리고 2월에 본인의 수익금을 받으셨습니다. 맞습니까?
저 사람이 처음에 저한테 약속한 10만 불이 아니고
네.
1,000불인가 그렇게 돼서 그때부터는 저는 저 사람이 저한테 그 사기를 쳤구나 그 생각을 했습니다.
He gave me $1,000 check instead of $100,000 that he promised to me from the beginning. So then I realized that this was all fraud.
So you got $1,000 check for January and February?
1월, 2월에 1,000불씩
천불
받으셨나요?
그 책이 아니고 캐시로.
It was a cash, not a check.
It was cash. Got $1,000 for each month?
네,
그러면은
천불.
매달 1,000불 캐시로
천불 정도
받으셨나요?
됐습니다.
It was about
그게
$1,000.
헌데 그게 10만 불이 아니라
It was not
천불이었다고.
$100,000. It was $1,000.
Okay. Then in March 2020, the store had to close because of COVID. Is that right?
그리고 3월 22일부터는 코비드 때문에 가게가 닫아야 됐습니다. 맞습니까?
네, 맞습니다.
Yes, correct.
Okay. And the store reopened in the summer of 2020, around September. Is that accurate?
한 2020년 9월 정도에 가게가 다시 오픈했습니다. 맞습니까?
아닙니다.
No.
When did the store reopen?
가게가 언제 다시 오픈했죠?
잘 모르겠습니다.
I don't know.
But when the store reopened, isn't it true you decided to run the store?
가게가 다시 오픈하고 나서는 본인이 운영하시겠다고 하지 않으셨습니까?
저는 운영을 못합니다.
I don't know
거기
how to operate it.
노스캐롤라이나 가지도 못하고
And I can't even go to North Carolina on my
그리고
own.
그때는 제가 그 고등학생 아들이 있어서 학교를 픽업을 했기 때문에 운영을 할 수가 없었습니다.
My son was in high school at that time, and I was giving him a ride to places his high school years, so I wasn't able to operate.
Did you tell Mr. Park that he could not continue to run the store?
박 선생님께서 그 가게를 운영하실 수 없다고 본인이 말씀하셨습니까?
무슨
What do you mean?
Did you tell Mr. Park that he could no longer run the store?
박 선생님에게 더 이상 가게를 운영하지 말라고 말씀하셨습니까?
저 사람이 코비드 때 끝나고 가게에 있는 돈까지 다 가져가서 돈이 한 푼도 없었습니다. 그래서 가게는 그냥 클로스가 됐습니다.
After COVID, Mr. Park took all the monies that were at the business, were involved business, so the store was closed.
Right? But when the store reopened, isn't it true that you locked Mr. Park out of the business?
하지만 그 후에 가게를 다시 오픈했을 때 선생님께서 박 선생님을 들어가시지 못하도록 막지 않으셨습니까?
제가 운영을 안 했는데 어떻게 저걸 합니까? 그리고 저 사람이 지금 파트너라고 그러는데 만약에 오픈이 됐으면 저 사람이 왜 못 들어갑니까?
If it was open, why didn't he the one that went in? I mean, I wasn't there to operate the business, so how am I supposed to stop him from operating the business? I wasn't there.
Who did you hire to run the business in the summer of 2020 as the manager of the store?
2022년에 가게를 매니저하도록 어떤 분을
저는
하셨습니까?
그런 적 없습니다.
I never did. I never
매니저
hired
한
a
적
manager.
없습니다.
So what happened to the profits that the store made starting in September of 2020?
그러면 2022년 9월부터 만들어낸 수익은 어떻게 된 겁니까?
수익이 어디 있었습니까?
What do you mean by profit?
Well, the store resumed operations, right?
가게가 다시 시작하지 않았나요?
가기 모릅니다.
I don't know.
So are you telling this jury that you never managed that store even remotely?
멀리서라도
안 했습니다.
비즈니스를 운영하셨다고 안 하셨다고 배심원들 앞에서 말씀하시는
네,
겁니까?
네,
Correct,
안
I
했습니다.
didn't.
Okay, so to your knowledge, who did operate the store after COVID ended?
코비드가 끝나고 누가 가게를 운영했습니까?
저는 누가 와서 인베스트를 해서 자기가 오픈을 하겠다고 그런 사람이 있어서 그냥 해보라고 했는데 저는 안 했습니다.
There was someone that who had an interested in making investment and wanting to run the business, but I didn't do it.
So did you sell your interest in the store?
그러면 가게의 그 권한이나 쉐어를 다른 사람에게 양도하셨습니까? 팔으셨습니까?
안 했습니다.
No.
So what happened to the store?
그러면 가게가 어떻게 됐나요?
가게가 그 사람이 했는데 이게 불법이래 가지고 몇 달 뒤에 경찰서에서 그거를 클로즈를 시켰어요. 저 사람이 27개월 동안 했다는 거는 그거는 말이 안 되는 소리입니다. 그 가게가 불법 이게 처음에 저는 그 저게 지금 아까처럼 리글 그 합법이라고 그랬는데 제가 나중에 들어가서 코비드 때 문 닫고 보니까 이게 노스캐롤라이나도 불법이더라고요. 그리고 딴 사람이 뭐 했다고 그래도 그게 문 닫았 그거 경찰서에서 와서 그걸 문 닫았다고 하더라고요.
When we first started the business, I was told that this business model was illegal. But later I found out after COVID that even in North Carolina, the business itself was illegal and police came and shut down the business.
Do you know when that was?
그게 언제였는지 아시나요?
잘
I
모르겠습니다.
don't know.
Isn't it true that that was in December of 2022?
2022년 12월 아닌가요?
저는 기억을 못 하겠습니다. 저는 안 했습니다.
I don't
네.
remember. I didn't do it.
But isn't it true that you ran the business from September of 2020 to November of 2022? Isn't that true?
2020년 9월에서부터 2022년 11월까지 본인이 운영하신 게 아닌가요?
제가 다시 말하지만 저는 경험도 하나도 없고 노스캐롤라이나도 갈 수도 없었고 그리고 그 비즈니스를 잘 모르기 때문에 저는 안 했습니다. 할 수가 없었습니다.
Once again, I can't drive myself there. I don't know how to operate this type of a business, so I didn't operate the business.
Do you know who the employees were who worked at the store?
그럼 가게에서 일했던 사람들이 누군지 아시나요?
모릅니다.
No.
Do you know who the managers were? who worked at the
매니저들이
store?
누군지 혹시 아시나요?
모릅니다.
No.
Did you take any action to protect your investment during COVID?
코비드 기간 동안 본인께서 투자하신 금액을 보호하려고 뭐 어떤 조치도 하시지 않으셨나요?
저 사람이 돈을 저한테 자기가 투자하겠다는 돈을 지금까지도 하나도 안 주고 있습니다. 저는 거의 한 30만 불을 잃었습니다. 저 사람은 돈 투자 하나도 안 하고 지금 무슨 말을 하는지 모르겠습니다.
I don't know where this is going. I lost about $300,000 through this business. He hasn't made any investment till this day, so I don't know.
I want to show you what's marked as Exhibit 6.
번 증거 자료 보시겠습니다.
Is this a true and accurate copy of a document you provided to us during discovery?
디스커버리 기간에 저희에게 전달하신 정확한 서류가 맞습니까?
제가 이건 전달한 거 아닙니다.
I don't think I provided this document.
If you look on the second page, there's a letter addressed to you dated July 25th, 2021. Is that
번째
your
장을
address?
보시면 본인의 주소가 여기에 있는데요. 아닌가요?
예, 제 주소는 맞지만은 이거는 저는 잘 모르겠습니다.
Address is correct, but I'm not aware of this document.
I think we got it. This address, so. This one. All right, yeah, I think it all came. Do you recall being told that the lease was going to be terminated?
해지될 위기에 놓였다는 내용을 들으신 적 있으십니까?
저는 고마웠죠. 빨리 끝나면 왜냐하면 계속 제가 그 리스를 계속 제가 돈을 내고 있었을 거예요. 코로나 때도 돈을 냈고 저 사람이랑 뭐 매든이랑은 익스펜스나 뭐 전기세 뭐 이런 것부터 1원 한 장도 낸 적이 없습니다. 1불도.
Yes, and I was very glad because I was the one who was paying for the utilities and lease and everything. So I was glad that this was about to be end because either Mr. Park or other 두 번째 사람이 누구셨죠?
매든이요.
Medin hasn't paid any to lease or utility, so I was glad.
So when this letter came in and you were told by Ms. Lupton that the lease was not going to be renewed, what did you do?
업튼 선생님 측에서 리스가 이제 해지된다라는 이걸 받으시고 어떻게 하셨습니까?
저는 아무것도 안 했습니다. 그 저는 이게 빨리 끝나기를 바랬습니다.
I didn't do anything because I was wishing this to be resolved, so I didn't do anything.
So the lease was set to expire on August 31st, 2021, as per the lease agreement, right?
Can you repeat the date again? Sorry.
So if you look at exhibit 3,
3번을 보시면
first page,
첫 번째 장을 보시면
it says that the lease shall end at 12 midnight on the 31st day of August 2021.
2021년 8월에 이 리스가 끝난다고 되어 있는데 맞습니까?
아, 그리고 제가 들었는데요. 이 전에 이 건물이 팔렸다고 들었습니다. 5월 달인가 6월 달에.
I was told that the building was sold even before this term, like a May or something.
Okay? That the building had been sold by Ms. Lupton or her company?
럽튼 씨나 럽튼 씨의 회사가 그 건물을 팔았다는 말씀이십니까?
네, 그렇다고
Yes,
들었습니다.
that's what I was told.
But the lease ended pursuant to the lease agreement, August 31st, 2021, right?
하지만 2021년 8월 30일에 계약서대로라면 그때가 해지입니다. 맞습니까?
네, 맞습니다.
Yes.
And then this exhibit 6, she says
6번에
that she's
보시면
selling the business. And that's when you became aware that she was selling the business, selling the building, I'm sorry. Is that right?
빌딩을 팔게 된다는 거를 이 서면을 통해서 그럼 아시게 된 건가요?
아니요, 딴 사람한테
No,
들었습니다.
somebody else told me.
Mr. Park?
박 선생님이
아니요,
말해줬는데.
저 사람이랑은 뭐 저랑 연락이 없었습니다.
No, there was no communication between me and him then.
So who would have told you?
누가 말해줬지요?
그 노스캐롤라이나에서 뭐 와서 뭐 투자한다 저기 런하고 싶었던 사람이 얘기해 줬습니다.
The one who had an interest in possibility of running the business told me in North
Right.
Carolina.
Is it true you also learned from the person who was running the business at that time, which was not Mr. Park, right?
그때 비즈니스를 운영하시던 사람에게서 들으신 거 아닙니까? 박 선생님은 아니었고요.
네, 아니옵니다.
It
네.
wasn't Mr. Park.
But did you talk to whoever was running the business?
그럼 그때 비즈니스를 운영하고 있는 사람에게서 들으신 겁니까?
그 후에 들었습니다. 이건 나중에 들었습니다. 그때 들은 게 아니라 몇 년 후에.
I heard about it years
이때
later.
들은 게 아니라
Not at this time, but years after.
그리고 제가 그런 다음에 렌트를 그 후로 그 전에서부터 7월인가 8월 달서부터 안 냈습니다.
And I stopped paying rent from July.
Of 2020?
2020년인가요?
20년인가 21년 그러니까 리스 끝나기 전서부터 안 냈습니다.
Right before lease ended.
Right before the lease ended. So it would have been 2020, the lease ended in August 20, no, I'm sorry. 2021 is what you're saying, July of 2021.
그러면 2021년 7월에
7월인가
안
6월인가
나셨다는
7월인가 8월인가부터 안 냈습니다.
I'm not sure July, August, June, but yeah.
But that
그래서-
was right before the lease ended is the bottom line.
하지만 계약서가 해지되기 바로 전 그 같은 연도까지만 내신 겁니다. 맞습니다.
네, 맞습니다.
Yes,
그리고
yes.
그 후는 저는 뭐 거기랑 연결된 게 없으니까.
Yes, and since then I don't have anything to do with that.
All right, so you paid the lease rent from throughout the COVID time and then all the way until the end of the lease in July of 2021. Am I understanding that correct? Is that
그러면은
correct?
코비드 기간에도 렌트를 내셨고
네.
그리고 2021년 뭐 7월까지 정도도 렌트를 내셨다고
네,
제가
냈습니다.
이해해도
네,
되겠습니까?
냈습니다.
Yes.
But you never asked anyone where the money was going that the store was earning?
그러면은 렌트비를 내고 계셨는데 비즈니스에서 발생하는 수익금이 어디로 가고 어떻게 되고 있는지를 누구에게도 묻지 않으셨습니까?
제가 오픈도 안 했고 그다음에 제가 그 코비드 기간에 한번 가봤는데 그냥 그 가게가 그냥 쓰레기장이었습니다. 거기 막 그냥 그 너무 더럽고 누가 운영도 안 하고 뭐 이러니까 너무 더럽고 그래가지고 나중에 어떻게 설명을 했지? 두ring 그 코비드 타임에 가보니까 그 한 8개월인가 그 가게가 너무 지저분하고 뭐 그래가지고 되게 많이 걱정을 했습니다. 그게 예.
I went back to the business during COVID and it was really trashed. I mean, it looks like there was not the place has not been taken care of for even those 8 months. So I didn't know what to do.
You talk to Mr. Park?
박 선생님과 이야기하셨나요?
안 했습니다.
No.
Where did the business have their bank account?
비즈니스가 은행을 어디로 가지고 있었죠?
은행이 거의 없는 게 돈을 벌었어야지 은행이고 저 사람이 그 돈이 저 사람이 은행이 없었습니다.
I don't think there was bank because there was no profit and he didn't earn any money.
Throughout the whole time it was in operation, you say it never earned any money.
그러면은 운영하는 동안 한 번도 돈을 벌지 않았다는 말씀이십니까?
1,000불, 2,000불 벌었는데 저 사람이 은행에 넣을 정도로 뭐 돈이 뭐 그냥 현찰만 계속 뭐 몇천 불 이렇게 돌았던 거지. 뭐 저는 저 노스캐롤라이나에다가 비즈니스 오픈을 그 은행 오픈을 안 했습니다.
I never opened a bank in North Carolina and also he may have earned $1,000 or $2,000, but I think it wasn't really went into the bank. It was just a cash that kind of flowed around.
So when we sent you a discovery request, we asked you to identify every bank, credit union, or other financial institution used in any way by the business at that location. Your response was, please reference all documents produced herewith. You did not produce any bank documents to us,
저희가 예전에 요청하실 기회를 제2금융권이든 은행에
correct?
관련된 재무 기록이나 은행 어카운트에 관련된 걸 저희들에게 다 알려달라고 했는데 그럼 뭐 답변을 참조하라고 했는데 그러면 없었다는 말씀이십니까?
없었죠. 돈을 번 게 없었으니까.
There was no profit, there was none.
And isn't it true that you never sent a distribution check to Mike Park at all, correct?
디스트리뷰션 체크를 마이크 박 선생님에게 한 번도 주신 적 없습니다. 맞습니다.
예, 없습니다.
No.
And you never sent a distribution check to Jamie Madden either, correct?
또 그 채미 매든 씨에게도 디스트리뷰션 체크를 전달하신 적 없습니다.
없습니다.
No.
Judge, if I may have a second with my client.
Judge, is it okay for interpreter to switch?
Pardon me?
Let's take 1 second. Let's see
Sure.
where we are with the
Yes.
examination here.
I have nothing further, Your Honor.
All right. And how much time do you estimate for your examination, Mr. Begg? So nothing further? You can step down, ma'am.
네,
끝났나요?
끝난 거겠습니다. Am I excused? Witness.
Yes, sir. You can
네.
step down.
앉으시면.
감사합니다. 이거 가져가도 돼요?
Do I need to take this in witnesses?
Why don't we'll leave that there for now. That's fine.
Yeah, please.
Okay, members of the jury, we've been going about 2 hours. Let's just take a quick 5 stretch break.
Your Honor, we're gonna need about 10 to 15 minutes to get ready for the deposition, so can you give us 15-minute break?
All right, so just let us know when you're ready to proceed and we'll call you back when we're ready.
Thank you.
All right, jury.
Right. Let's,
I want to leave that big old Jeff.
yes. We're each going to have our copy, but I want to do this. What highlight so that you know. You already highlighted yours? Want to highlight mine? Actually,
All right, we're off the record.
I'm not that good. So let's go. What's the first page? 6. I remember 6. 6, 1 through 8.
Is his English really that bad? Is his English
This is
really
where
that
we're
bad?
reading parts. We're not gonna read the whole thing.
He's been here close to 40 years.
Yep, because we're not tendering the whole
Right,
transfer.
He understands everything. Why isn't,
Okay, so what do we say? Page 6,
I would think
1
that
through-
on screen on time.
Okay.
Our exhibits,
Yeah.
they have to be admitted into evidence.
Oh,
Right,
Yeah.
next.
That's why you see I was waiting
page
until he
7.
said admitted, like he was asking them, is
7
this a
through
true
15.
copy? So that one document was the
Okay,
lease
7 through
termination when he
15.
said, I don't know, I don't
And then
remember it.
25,
And his attorney was like, no, they were objecting.
so when you put it on, it goes on there immediately?
Yes.
all the way down. I like it. I'm taking your ideas.
4 through 16 on page 9.
4 through 16. Okay, so we'll bring that down. Okay,
4 through 7 on page 10.
I'll be right back. I'm running
please go
to
ahead.
bathroom.
okay.
All page 11. It's my moment to shine.
That's right. Have you ever performed on?
No, Lord.
You're gonna do great. Just tell the truth.
I mean, all I gotta do is read, as long as I can figure that out.
All right.
1 through 6 on 12.
12.
And then you start, what is the thing? On line 11.
Line, what is the date? Okay, and go to
And
when?
go to 22,
Okay,
13, 15 through 25.
the end of the page.
1 through 13.
13. 2 to 23. No. Okay,
15, 7 through 14.
7 through 15. We're gonna be done quicker than I thought.
It's very,
Yeah,
16
16, okay.
is 10 through 23. Yeah.
10 through 23. I like that. Very good, okay.
And 17 is 4 through 12.
Also, yeah,
Right.
okay.
18
I'm so glad you're on the deposition listing. So I think that really gave you. some
Oh, yeah.
context.
Yeah. I
Okay,
hope I-
18,
18 is 3 to 7.
okay.
19 is 7 to 25.
That would be number 1 also up here, right?
1 and 2.
Okay,
And then that's it on page 20.
okay,
Page 21 was 14 to 25.
okay.
22 is 1 to 17. This is where it skips to 29.
Okay,
And on 29 is 23 through 25.
23, wait, no, okay.
And then 1 and 2 on the next page. And also 10 through 16.
3 through 16. They're not even going to notice some of this. Okay,
31, 11 through the end. Through 25.
okay. All right,
32, 1 through 12.
I'm glad you went ahead and highlighted yours. That makes things a lot quicker. I was thinking that we were going to do them both.
Oh,
1 through 12, right?
yeah, 1 through 12, that's it on
Okay.
32, and then 5 through 8 on 33.
So since we're doing so well on time, you can use dramatic flair.
Right? That's what I was thinking. I was like, I read it so fast in my head, so.
Yeah, gotta read it slow.
Yes, okay,
And you noticed when I was doing opening, I had to consciously try to slow down.
right. Okay,
I don't know how
I'll
I-
try to slow down then, because she answered very slow. 23 to 25
23 to 20.
on 34.
34. 34 is 23, 25. That's a
Mhm.
question.
And it continues on 35(1) to 3.
Okay,
And I believe that's it that we did.
we
And then
did,
there's like frost, August, frost.
all right,
And we didn't do anything on frost.
right. He'll ask you to read that.
Yes.
I don't know if he's highlighting or getting it ready. So,
I never saw their email. How much time you think we got? For me to run to the bathroom quick?
go ahead.
I'll be super.
Yeah, that way then. So I think the jury was not binding.
The receipt part was really good. Like, I don't know, should be in the store.
Yeah.
My wife
TVs
bought it
and
on
computers.
Amazon. No, I don't have any receipts.
But the TVs are still in the store. Wait a minute, he closed in 2022?
I wanted to ask him how many times he says, I think he's lying. He said that he doesn't drive, but then he said he can't go to this, he couldn't go to the store because he was driving his teenager.
Yes.
The list of expenses that he had, that they hadn't written. I just called Artie.
Uh-huh.
Artie paid for the bathrooms, the air conditioning.
Right. What kind of hotel did you stay at that cost $10,000? And what kind of meals? I mean, is this like Wolfgang Puck or something?
He
I'm
came up,
impressed.
he came up,
I like how you roll.
he came up maybe 10 times, if that. Now it's online, hot deal or hot motel or hot, some kind of deal. And I paid for his
Right.
motel. And then, again, Artie is just sending me a text
Right.
on the receipts that she had, that she paid for.
I don't think the jury's buying the fact that he paid the rent for a whole year and never wondered where the money was going.
And then,
He heard about the
And
property
then-
being
The
sold.
business,
And then-
the building.
and then when it reopened, I was never there.
Well, you were locked out, right?
Not locked out. He just called me and said, let me run it.
Okay.
So fine. I rented, or he had rented an apartment up there,
He did.
which I stayed. At the time, I had
So
some,
did he stay there ever?
I stayed there half a year.
Did he not drive? I mean, is he telling the truth about that at least?
Well, he doesn't want to drive on highways,
I get that.
but he drives around it.
I don't want to drive on city street.
Yeah.
So at the time, the leads and everything,
Right.
I had some financial issues.
Right.
And we talked about how it would be better to have it in his name, the
Right.
lease. And shortly after, 2-3 months into it, it says, Mike, I need to get this into your name. And then we got shut down. And we didn't pay rent for while the public was.
All right, so I'm thinking we're gonna finish this up. Jamie Madden today, and so that means tomorrow, we're gonna start with you. And we're gonna go from you to their direct of Sean, and then we'll go into closing arguments. So that means tonight, when I get home, I gotta do your changes to your outline. So a lot of what I'm gonna change is gonna be based on what we've learned here.
And
Close it.
okay, if I was gonna spend 100,000 on that location. So
Yeah.
All right, they're ready.
You think helpful?
Okay, if we could retrieve, well, I don't know, did they step in the side? I don't know if I could enlist y'all to try and get them back in the courtroom.
Will you question him tomorrow again?
Yes, you bet.
Do you think we should ask him about boosters?
What about it?
What's that?
I just think he's trying to paint this picture like I don't really speak English, so how could I run the business? But he says he has a booster and coming, so I'm just trying to understand like who's running that or how's that getting?
is he coming back on stand?
He'll come back on stand for when they call him, and then I get another cross examination. So this is a good point. Let's keep a list of.
Why do you need a translator and you've been here 35, 40 years?
Yeah,
When did
I'll
you
add that
come
in
here?
here. So everything but fraud. And then that might impact,
Ask him to get naked and then
how they're supposed to answer attorney's fees and the rest of it.
The stitches that.
I don't know.
This is
Like,
bullshit.
if you get-
Into the case.
Anyway,
gonna have a copy?
Did she need a copy of the transcript?
No, because you're gonna take down as the questions I asked. So it's gonna be, I'm asking her questions from portions of the transcript. And she's gonna answer from portions. So if you take that down, I don't think you need a copy of the transcript. The court may disagree, but,
well, I mean, sometimes it's helpful for a court reporter to follow along by reading,
oh, okay.
if that's what you're wanting to do.
Is that what you're wanting to do?
Yeah, well, just because you're reading, just to make sure, I mean,
Do I give her the court's copy?
I mean, that's fine. All right, so, and just, before we go on the record, plan of attack, as you told me, that's about an hour to get through the depot on both sides. So I would think that, we finish that up and then we're done for the day.
I think
Okay.
so.
So I think we can excuse our interpreters then?
Yes, right.
Okay. All right, but we would need them back tomorrow.
Did you see the judge?
Right, and, but your client is gonna take some time.
Right, so tomorrow morning, we'll, assuming we get Ms. Madden's complete today, I'd like my client will be the lead tomorrow. I don't know, maybe an hour from my.
At least, yeah. All right, and so, folks, I'll just let you know, I would say we're not gonna need you till 10:30 tomorrow morning, okay? All right, 10:30 for our interpreters. All right, then with that, we're back on the record, and it looks like the jury's ready to proceed, and so however you want to present, you can go ahead and get situated as we bring in the jury.
You doing okay, or do you need more vodka? I mean, water.
Want to sit there. I want him to know we're on top.
Hey, just got to see everyone. Plaintiff may call their next witness.
Your Honor. Plaintiff calls Jamie Madden to the witness stand.
All right, so this would be, well, you don't just swear, this would be a presentation of a deposition that you're tendering. And as I understand, the relevant portions have already been provided to opposing counsel. So any objection to the presentation of this deposition? All right, so with that, Mr. Collins, you can proceed.
Good morning, Ms. Madden. The purpose of this deposition is for you to testify via deposition at the trial between Mike Park and Sean Lee. So first, I want to introduce you to the jury. Would you state your full name for the record?
Jamie Madden.
Okay. Tell us about your relationship with Mike Park, the plaintiff.
I known him for a long time. He was my best female friend. I knew from her that he was her friend, and my girlfriend introduced me to him, and we got to know each other since then. And he was just, very nice gentleman and very good to us. We had a good relationship.
Had you ever done any business deals with Sean Lee prior to this one?
No.
Okay, so tell us about this particular business deal. How did you learn about it?
Oh, I don't know too much about the business deal. All I know is Michael Park, and he just asked me, hey, do you want to invest some money to this business? I say, what's the deal? And he say 10% profit sharing in every month and stuff like that. So I trust him because he was always a very honest guy and a very generous guy. And all of our friends trust him. So I didn't have any problem to believe him. So I say, oh, okay. If that's what you think, you can help me. I say, well, that's good. So that's why I decide to do that.
Prior to that first conversation with Mike Park, had you ever met Sean Lee?
No,
Did you actually meet Sean Lee at some point in this process?
I think I only met him when I handed him the check and we went to bank together to get notarized. And
Did you ever meet Sean Lee after that transaction?
I think once, if I remember right, because I was going to complain to him that I didn't receive the 10% like what he promised.
So did you have any negotiations with Sean Lee about this business deal?
No,
Who took care of the basics of setting up the structure of the deal? The 10%, in other words.
well, okay, I always call him, Park. So Mr. Park.
So the $50,000 that you were going to invest, that dollar amount came from whom? Who told you that dollar amount?
Mike Park.
So my question for you was the 10% profit share and ownership interest. Where did you hear that term from? Who did you hear that from?
Well, 10% from Mr. Park.
Okay. So you did not ever negotiate any of the actual terms with Mr. Lee, right?
Mr. Lee? No, I don't know him.
Okay. So I'm going to show you what's marked as Exhibit 1, Plaintiff's Exhibit 1. Can you see this document?
Yeah, that's mine.
And okay, is this a true and accurate copy of the check?
Yeah, that's the transaction. Mike Park told me that day, he said, I'm going to send my friend. He is my partner and he's like me. So you can trust him. Give him the check. That's what he told me. So
And that is, I'm sorry, go ahead.
that's why I wrote the check to him. Mr. Park asked me, he say he cannot come because he was in, I don't know, North Carolina or South Carolina somewhere. So he say, Sean Lee going to come and meet you to pick up the check. So I say, okay.
Okay. And so this is your signature at the bottom of the check, right?
Yeah, that's it. Okay.
And so at this time, we'd like to tender this exhibit into court. This has already been admitted into court. So let's move on to the next section. What is the date on this check?
Date is December 16th, 2019.
And is that the date that you actually wrote the check to Mr. Lee?
Yes.
What's the dollar amount of this check?
$50,000.
To whom did you make this check payable?
Sean Lee.
Okay, could you tell the court what the purpose of this check was for?
The 210 skills sweepstakes.
Okay, now I'm going to show you what's been marked as Exhibit 2. Can you identify this document?
Yeah.
And is this a true and accurate copy of the agreement of partnership?
Yes.
So this is the document that you signed, is that correct?
Yes.
And were you present when Sean Lee signed this?
Yes.
And this at the bottom, was there a notary public also present?
Yes.
Okay. And at this time, we'd like to tender Exhibit 2 into evidence. Assuming the court admits this document into evidence, I'd like to ask you a few more questions about this, Ms. Babbitt. Let's walk through this agreement. Who typed this agreement up?
I don't know. He brought with him. I don't know who wrote it, but he brought the paper.
You're saying Mr. Lee brought the paper,
Mr. Lee, yeah.
okay?
And right after Mr. Park told me that Sean Lee going to come meet me, and he come with this.
So was Mr. Park present during this transaction?
Huh?
Was Mr. Park present when you signed this?
No.
Okay, and then did you sign here?
Yes.
Okay, and what is the date that you wrote in?
December 16th, 2019.
Okay, and did you see the notary public sign this document as well?
Yes.
Okay, the first paragraph says 210 Skill Sweepstakes is giving 10% of its shares to Che S. Madden. And that was the agreement that you reached for the payment of the $50,000, right?
Yeah.
Is that you were going to get that 10% as ownership shares? Was that your understanding?
I guess.
Okay, and then the next paragraph says, for amount of $50,000 in addition to 10% shares. That's the $50,000 that you paid to Sean Lee, right?
Yeah.
Okay, and so that next paragraph says 210 Skill Sweepstakes will pay 10% of future profits to Che S. Madden. What was your understanding that meant?
I only understand 10% profit sharing.
Right? And so that's what that 10% was 10% of all future profits, profit sharing, right?
Yeah.
Okay. What else did you do during your meeting with Mr. Lee?
That's it.
Okay, what happened next?
He never keep the promise.
Right. So did you keep track of what was going on with the business?
No, not at all. And I asked Mike Park, just to return my money because I don't want this and I don't want to go through a headache. And I don't want to hassle around because you guys don't keep the promise.
Did Mr. Park return your money?
Yeah, after a while. Yeah, he said he will return my money, and he did. He did it monthly payment to me.
Okay, but he paid you the full $50,000, right?
Yes, he did.
Okay, did Mr. Lee repay any of the money? Did Mr. Lee repay any of the money to you?
No. I never get to see him anymore.
And Mr. Lee never sent you any profit sharing checks either, right? Or payments?
Sean Lee? No, never. I don't see him.
You told Mr. Park that he could have your 10% ownership interest, right? Were we supposed to be at the bottom of page 20? I'm sorry, Your Honor, can we go off the record for a second?
Do you need to approach or?
No, I think I made a mistake in reading the transcript. Did I make a mistake there?
What page are you on?
Page 2025? No, we're going to the next page, right?
Mm-hmm.
Okay, I'm sorry.
When we're still on the record.
Get back on the record, Your Honor, thank you. You told Mr. Park that he could have your 10% ownership interest.
Yeah, he said, I don't want nothing and you can have it all. And I got my $50,000 back and it's all yours,
So, but you did not put that in writing. There was no written agreement, assignment agreement.
No.
But you understand that you transferred to Mr. Park your rights under that partnership agreement, right?
Tell me one more time.
That everything that is shown up in this agreement, that I'm going to share one more time with you, so you can see it, that the rights that are contained in this agreement you transferred to Mr. Park.
That's right. Yeah. Absolutely. Yeah.
So Mr. Park had the right to your 10% of shares in the company.
That's right.
And did Mr. Park have the right to 10% of future profits?
That's right. That's why I gave all this paper and a copy of the check to Mr. Park.
Okay, and you freely and voluntarily assigned your rights under this partnership agreement to Mr. Park, is that correct?
Absolutely right.
Is there any written document made between you and Mr. Park stating that you were giving him the right to collect money on behalf of you from John Lee?
Well, I didn't write anything, but I verbally told him, yes.
So is it reasonable that you want money back from Mr. Park?
I try to call Sean Lee many times, but if I call maybe 10 times, he answer maybe one time. And during that time, I don't want to waste my time and try to chase him. So I just decide to return my money back request to Mr. Park.
I have just a couple of redirected questions here, okay? I'm going to show you what's marked again as Exhibit 1. Sorry about that. And this is the check you wrote, is that correct?
Mm-hmm.
And to whom is this check payable?
It's payout to is Sean Lee.
Who did you hand this check to?
Sean Lee.
Did you give this $50,000 to Mike Park?
No, Sean Lee. And he received for Mr. Park.
Okay, and this contract is between you and Sean Lee, correct?
Absolutely.
Now, was Mr. Park a part of this contract?
No, and that's absolutely me and Sean Lee. And I turned this right to Mr. Park.
Right. And so this 10% of the shares and the 10% of future profits all came from Sean Lee, didn't it?
Should.
That's what it says though, right?
Yeah.
Okay. And rights under this contract, you transferred that to who?
To Mr. Mike Park.
Okay. Did you receive some cash from Mike Park in January and February of 2020, right after the agreement started?
I think I did.
Okay, and so the only deal you had with Mr. Lee is what we saw in this agreement of partnership, right?
That's right. That's right.
And the check you paid to him.
That's right.
I have nothing further, Your Honor.
And are you offering the services of your paralegal for? All right, you can proceed when ready, Mr. Begg.
Very brief. I'll turn your attention to page 25, please. And I'm going to begin reading a question that starts at line 25 and flows over to the top of page 26. Let me know once you.
I'm ready.
Question. So just to make clear that at the time of giving money, it was your understanding that you are making investment to the company, right? Is that the correct understanding?
Oh, I didn't. He was not asking me to invest the money in the company. He asked me to just put money in there to give me 10% profit sharing. He didn't tell me ownership. We didn't tell me nothing. I told him, I don't like to get any headache, and I basically invested in you. That's what I told him at the beginning. And
Is your understanding that you invested money to Mr. Park, not the company?
well, that sounds more like.
Okay, so like my understanding is that you mainly give money to Mr. Park because you only know Mr. Park.
That's right. I just don't know. And you know, he was very honest guy. He paid me back. He, you know, because he know that I don't like to deal with that, you know, not to people who don't keep the promise. Yeah.
So it's your understanding that you invested money or you give money to Mr. Park and Mr. Park paid that money to you. Is that your understanding now?
Yeah, he paid me back.
Anything further on to do with this deposition?
No, Your Honor, that's it.
All right, you can step down, man. All right, then is the proposal, we've covered enough for today?
Yeah, Your Honor, I'd like to start with Mr. Park Fresh tomorrow morning if we could.
All right, there's a jury, we've covered a lot of ground today. Thank you so much. We're well ahead of schedule. And we'll wrap it up for today. So one more thing I think I might not have covered with you, just to be clear, is that in terms of the timing for tomorrow is I'd like to pick up again at 9 o'clock. And so the plan would be y'all can be back there ready to go at 9. We'll be out here barring some unforeseen circumstance, ready to go as well. And so go ahead and plan to, especially if you're coming from the outermost reaches of the county for traffic, go ahead and plan for bad weather, build in a little extra time, because unless all of you are here, we can't start. And if we want to end on time, we got to start on time. So build that in. You can be here as early as, I think, 7:15 if you want to get buzzed in earlier. And then we'll go until we can find a good stopping point for lunch, and do the same thing we did today, give you about an hour for lunch. You feel free to pack a lunch if you want to use the refrigerators in the back, or leave the building again like you did today. If anything comes up between now and tomorrow morning you think that, again, is going to delay your arrival, make sure you give us a call or email to Mr. Derryberry, because if we don't hear from you, then we assume we got to go send the sheriffs out looking for you. And so with that, unless anyone has anything they need to flag, you can stay behind, but otherwise, we'll see you back at 9 a.m. tomorrow. Please don't discuss the case with anyone, including amongst yourselves, or doing your research about the case. Thank you so much. You can stay back. All right. Well, then, before we run screaming for the exit, is there anything we can do to maximize this time we have? Anything at all you can think of on behalf of the plaintiff?
Your Honor.
All right. On behalf of the defense?
Making great time so far.
Sure. Agreed.
I don't want to make everybody mad at me, but if you wanted to do the charge conference,
We could at least flag some issues. We're still working on your charges is the issue that takes some time. And I think we'll probably be still doing that tomorrow morning, making sure we get the right patterns plugged in. I'll flag a couple issues for you to contemplate between here and when we pick back up. I think I do already have a verdict form ready for you to take a look at. So we'll email it over to you. I make a point of delineating actual versus nominal damages for claims, just because we've had cases where a jury rather has awarded damages that you might think are actual damages because they were in excess of 100,000, but they actually considered those nominal. And we've got recent case law, and that nominal is actually supposed to be a trivial sum. And so there's just a lot of issues that can come up, and I think that there is value in, not to get hyper technical and make a finding on each specific element, but just as it comes to damages, to make sure that we're very clear of what exactly it is they found and what is an appropriate award. So you'll see that in the verdict form, and welcome your thoughts on that. And I guess it's worth considering as well. I mean, I imagine there's going to be some motions made regarding some or all of these claims at the halfway and endpoint. And I'll say typically my practice is, once we've already made it this far, is to reserve ruling on those and let it reach a jury. But I will say that I am willing to consider those arguments on their merits even after a verdict, judgment notwithstanding. So, for example, so far, I don't think I've heard any evidence of clear and convincing justifying an award of punitive damages. Of course, that could change. So even if I we get that in front of a jury, and if a jury finds it, that may be something to clean up after trial. I just flagged that now so we're all on the same page and we can be aware of that. But until we have that consolidated jury packet, I don't know if there's really any point to digging in today. I didn't really see that many non-pattern requests. And offhand, there were several on the defense. I don't know if there weren't really any citations, so we're still trying to figure out maybe some of the origin of those. We'll see what we can find. But with that then, if y'all could try to be here just a few minutes before 9 so we can make sure that we're ready to go when the jury is. And if there's nothing else, we'll be off the record. See you tomorrow morning.
Good. Yes, we'll see you tomorrow.
All good.